May I please, my lords?
Yes, please.
So in this case, the petitioner has challenged me, lords, the impugned certificate proceedings for recovery of periods tax in areas in respect of erstwhile company, whereas the specified property of which was auctioned by the debt recovery tribunal. I am the auctioneer.
Yes, sir.
And your lordship, in the case of this very petitioner, has earlier disposed of one writ petition directing that because they rely upon revision order in the counter saying that the findings of the revisional authority that it's a transfer and section 19(1) of the Orissa that which provides for entire transfer. I have purchased specified assets. And the revisional authority directed that to establish the entire transfer business, you have to conduct investigation, which you have not.
Right.
So therefore, initially they granted registration and said, you go on, that will not weigh with your. And after 18 years, my lords observed in my lord's order that there is no outcome of any investigation conducted so far. And your lordship also quashed I have given, along with the compilation, it's in your lordship's record, my lords. The compilation, your lordship will kindly see.
14.322.
Yes, my lords. 14.322, my lords.
Correct.
Your lordship will kindly read along with the paragraph 2, my lords, kindly. In the impugned order dated 27/10/2003, that's a revision order passed by the Commission of Commercial Tax Odisha. In the petitioner revision case number so, it has been observed that the prerequisite for fashioning liability of the transfer company to the transferee company, as far as sales tax dues is concerned, is determined whether in fact there is complete transfer of all liabilities of the transfer entity. For this purpose, in paragraph 8 of the impugned order dated 27/10/2003, a direction has been issued to the department to gather evidence regarding transfer of business in entirety to fashion liability of the petitioner. 6 months' time was granted to the department for that purpose. Next, bills. While the present petition was pending, this court had, by an order dated 30th June 2006, recorded the submission of law and counsel for the department that he was not in a position to inform the court whether the said investigation had been completed or not. 3 weeks' time was set and granted for that purpose. Those 3 weeks have long since expired. In the past 18 years, during the pendency of the present petition, it appears that no investigation was in fact undertaken to determine whether the entire liability is of SIL. SIL means Sneha Industries Limited, got transferred to the present petitioner as a result of the takeover. So without the basic fact being established, a demand raised against present petitioner for amount due to the department by the erstwhile SIL, the transfer company, cannot be sustained in law. This is same, Milos, that SIL demand is now enforced by a certificate proceeding. And in the counter, they refer to the revision order, which your lordship was set aside. On the last occasion, on the prayer of my lord friend Mr. Mishra, he wanted that to inform your lordship, if at all there is any investigation, he will let my lords know about the outcome. That is why your lordship has granted 3 weeks.
My lord, today I am filing some documents which will satisfy that Snehadhara industry was entirely taken over by.
Let's see.
Tosal.
Let's see.
My lord, I have page marked page 4. The debt recovery tribunal's order. It starts with, this is to certify that the properties pertaining to Snehadhara Industries Limited, defendant number 1 in OA number such and such, on the file this tribunal have been sold as part of realization of debts due to financial institutions. The bottom 3 lines. Therefore, the concerned government authority are informed to extend such facility to not legible Major Tosali Cements Limited as per the rules and subject to payment of any such license, among those amount, royalty, etc. Then, my lord, if you, my lord, turn to page 6, page mark 6. This is the letter of possession from the beginning. In obedience to the order dated 26/2003, passed by the Honorable Presiding Officer, DIT Kotak, in 1A number, IA number such and such, arising out of OA number such and such, IDBI and others versus Major Snehadhara Industries Limited. Possession is hereby delivered to the authorized representative of Major Tosali Cements Private Limited.
What? Possession of these properties, sir?
Yes. There are three
of entire takeover in its entirety.
Yes.
It means assets and liabilities. All right. Not
including
just
goodwill,
assets.
your lordship have said.
You
In the-
understand takeover of companies. Takeover means takeover of assets and liabilities. You need to show us documents, not merely taking over some properties. Taking over of assets and liabilities of a company is different from handing over certain properties purchased in an auction.
My,
These are very different things, sir.
my lord,
Which is why you have to undertake an investigation, not like this. These are only documents showing some assets have been handed over. It's purchased in an auction.
my,
I think you probably didn't understand what was being asked of you. Just handing over some papers like this and saying, no, entirely taken over. This is not that kind of a takeover, sir. Takeover in a legal sense means taking over assets and liabilities of a going concern. That's what it means. And what you're trying to enforce is a liability.
my lord.
Unless the liability is taken over, you cannot enforce it against a succeeding purchaser.
But the statutory, the first charge is
In entirety. The word is used is entirety. Entirety means assets and liabilities. You say Counsel for the State has today handed over a bunch of documents which show that pursuant to the auction purchase by Toshali Cements Limited, the petitioner Toshali Cement Private Limited, of the assets of Messrs. Snehadara Industries Limited, bracket SIL, there was a handing over of those assets to the petitioner. Stop. This is not the same as that the petitioner took over all the assets and liabilities of SIL in its entirety, which is what was required to be demonstrated by the department. Full stop. In its order dated 14th March 2022, in writ petition civil 10451 of 2004, bracket Messrs. Toshali Cement Private Limited, the state of Orissa. Bracket. This court had noted how, in respect of the same SSC, an order had been passed on 27th October 2003 by the Commissioner of Commercial Taxes, Orissa, in revision case number PU-250/03-04, directing the department to, open quotation, gather evidence regarding transfer of business in entirety to fasten liability on the petitioner, unquote. In that case, it was noticed that despite the 6-month period having elapsed, no steps had been taken by the department to gather evidence concerning the transfer of the business of SIL to the petitioner, open quotation, in entirety, unquote. Paragraph. In those circumstances, by the said order dated 14 March 2022, the demand raised against the present petitioner was quashed by the court. Paragraph. The position here is no different. Full stop. The department is unable to show the court that the liability against the erstwhile SIL could be enforced against the present petitioner, which is the auction purchaser of some of the assets of SIL. Full stop. This was the prerequisite of section
My lords, in 19(1) of the Orissa Sales Tax.
19(1) of the Orissa Sales Tax Act. Which specifically requires the business of a dealer, open quotation, liable to pay tax under this act, unquote, to be, open quotations, entirely transferred, unquote. Full stop. The word entirely would mean transfer of both assets and liabilities, and not merely the purchase of some of the assets of the transferor company in a public auction by the transferee company. Paragraph. Consequently, court quashes the notice dated 5th October 2005, bracket Annexure 9, and 25th October 2006, bracket Annexure 11, and 9/11/2005 bracket annexure 13, which have been challenged in the present petition. The writ petition is allowed in the above terms, no orders is to cause. Just keep this on record. What about the second two connected matters?
That's That's are same.
Okay, in view
Only
all right. In view of the order passed today in 14/501 of 2005, the impugned notices are hereby quashed in each of these matters.
Weekly list item number 2.
Your Lordship director State Council to take instruction as to where I can be adjusted.
That the affidavit has not been filed, another date may be fixed.
We already had sought time in August, sir.
Twice your Lordship has already given
The
direction.
only difficulty is that the file I am not getting from the office is short date, 10 days.
Despite the
time.
orders dated 16th August and 20th October 2022, one more opportunity is sought to file by the State Council for the State for ascertaining if there's any vacancy in the body worker against which the present appellant, who has at present crossed the upper age limit of 45 years, can be accommodated. The affidavit positively be filed on or before 2nd January 2023. List on.
My lord, it may not be in the month of December, my lord.
No,
No,
we'll keep asking for adjournments.
That by that time I may cross the age limit. My lord. That will be the problem. Therefore, your Lordship.
No, they'll keep asking more time. This is the whole problem. Already twice they've stock more time. 12th January. 12th January.
Weekly list item number 3.
If your Lordship will
this
look to
item
the order,
3,
look
I
to
have
the order
entered
dated 25.
appearance. In W28 of 12, I have entered appearance for the opposite parties 7, 8, 9, 10. And as I have earned by virtue of the last order 25/7/22, a direction was given to the State Council to give the joint committee report with a copy. No copy has been served on us.
I see.
And it's last one.
But I have filed the affidavit today and I also served the copy.
You got a copy?
No. Today you will file.
He's saying no.
No,
But 2 copy I have already served.
no, you have not.
I'll serve another.
So far as I am concerned, you have given a copy.
They have also served a copy. They have given to the petitioner with the respondents.
I see. While copies of the affidavit filed today by the state have been served on the appellants, been served on the respondents. The needful be done during the course of the day. Seventeenth. This on 17th January. Okay.
January, 70 January. Interim order to continue.
Or interim order to continue.
My lord, item number 3, writ appeal number 280. We have appearance and filed a modification order, my lord.
All right.
Item number 4.
Item number 4, my lord. As per your Lordship's direction earlier, I have already substituted the deceased appellant, my lord. And it was IN number 3651 of 2020.
My lord, there are 2 appeals. So far as writ appeal 386 of 2012, that stands infructuous because that is against the interim order. Final order is challenged in the second writ appeal. So that may be disposed.
All right. Writ appeal 386 of 2012. This writ appeal is that's an interim order. In writ petition civil 2912 of 2011, which has already been disposed of finally, and against which order a separate writ appeal is already pending. That view of the matter, the present writ appeal has been rendered infructuous and it is disposed of as such.
And the next is
Next is WA 10 and
10.
11.
Yes.
In 10, I will substitute the deceased appellant. In 10, the deceased appellant, also the appellant in the writ appeal, my lord.
What are you saying, sir? I'm not follow.
My lord,
The appellant in writ appeal 10 has died, correct?
yes, my lord.
Have you filed an application?
Yes.
Substitution can be allowed.
What is your IA number, sir?
I number 3651, 2022.
One minute. Where is that? Where is it? 36. It's not there.
Already I have filed, my lord.
Sir, just see where just show him the paper book. Kindly take it out from this paper book, sir. Please take it out from us.
There are two appeals.
Kindly take out that application, sir.
Yes.
Writ appeal 11 copy is also not with us. 10 is there, which is against the final order. Very short question is there. If you writ appeal అది లిస్ట్ వచ్చింది My lord, 11 is there.
There was no order passed by my lord after 22/4/2014, my lord.
Sir, kindly take out the application you have filed. Please take out a copy of that application. You said you have filed an IA, right?
Yes, ma'am.
Where is that in the paper book? Tell us.
My lord, this is a writ appeal 10 of 13. I have filed in 386, my lord. WA 386 of 20.
So that is already infructuous, sir. What's the point in filing it in an appeal? You should file it in the appeal that is alive.
My lord, yes, your lordship is right, absolutely right. But on the same day, before previous date, your lordship, that was 386 of 12 was taken up. That is not disposed of.
Sir, there's no point. 386 is against an interim order.
Yes, my lord.
Final order has already been passed.
I will file separate substitution petition in.
That is what you should be submitting then.
Yes.
Instead of saying something else.
Yes, my lord.
You are submitting completely else. No wonder you are wasting the time.
No, yes, no.
You should have asked for more time to file a substitution in these pending appeals.
Yes, well, this pending appeal means 10 of 22.
10 and 11.
10 and 8. No, 11, I am not the appellant. 11
of 13, no instructions.
So 11, 2013, council appellant says she has no instructions. That is disposed of. In 10 of 2013, you say council appellant wants time to bring the legal representatives of the deceased appellant on record at his request list on 17 January.
Wiki list item number 5.
Very rare to see you in person, Mr. Mishra.
Why not, sir? Playing at home and playing in the field are totally different.
Exactly. Even for us.
In fact, my lord, in this case, I have asked him to come in person because much time he has spent in your residence.
Yes.
Your lordship, in this appeal, your lordship.
Yes.
I have filed a petition, your lordship, affidavit today.
Yes.
With copies, sir.
Yes.
There are certain documents which are a part of the LCR, local records, your lordship, but not before this honorable court in the writ petition.
Right.
But these are that strikes to the root of the matter, your lordship. So I want this matter to be taken up, and I have served a copy on
Just
my
now,
lap. Senior.
just now,
Yes,
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 copy.
yes.
We need some time to go through it.
All right. Mr. Mishra, the senior counsel for the appellant, has placed on record certain documents, copies of which have been handed over to counsel for the respondent, respondent number 2, who wants time
My lord,
to.
I have got, hey, Mr.
Here I am for 13 and 19, my lord. So far the respondent is concerned.
Sir, whom are you for, sir?
My lord,
Whom are you appearing for?
I'm appearing for on his behalf, my lord. I'm for the respondent. But what is the number? What is it? 9 to 11, man.
Copies of which have been served on counsel for respondents 9 to 11 and
I am for 13 to 17.
and 13 to
13
17.
and 19.
13 to 17 and 19.
Already, sir.
Right now.
All right. They need time to examine the documents and make submissions. list on 22nd February.
22nd February.
Right.
Item number 6.
May I please, my lord, kindly have a glance to the last order, my lord, on 5/9/2020.
Item number 6, that I am appealing for the opposite, but I have filed doctorate that it's not on record. My lordship on that date, my lord, 5/9/2022, my lordship was directed to find out whether
There are any vacant posts.
that my instruction they cannot, I filed a affidavit, my lordship, may stand me 10 days time.
All right. Constable, the MCL needs more time to file an affidavit in terms of the order dated 5th September 2022. List on 13th February.
13th February, my lord. 1, 3.
Weekly list item number 7.
Obliged, my lord.
Item number 7.
None appears dismissed.
Item number 8.
In this case, the respondent number 1 is the main contesting party, and AD is not back from respondent 1, my lord. So I will take fresh steps, my lord, in this case.
Tell us what the matter is about, sir.
Mr. Mahanti will argue in this matter, my lord. And he is on accommodation.
What does that mean? The notice to respond by 1 has not been able to be served. Fresh notice returnable on the next date. 13th February.
Item number 9.
May I please yours? This is a appeal against the order of the Lance single judge, wherein it has been the eviction proceeding was sustained, my lord. Last time, my lordship directed the state government to take the update position as of the existence of the slum dwellers.
Unfortunately, I haven't received instruction. My lords will give me 2
Mr.
weeks.
Mahanti states he has still not received instructions. Time to file an affidavit is extended up to 2nd January 2023.
Can I pray for status quo, my lord? Because
Now, nothing was passed so far. Why suddenly now? It's an old writ appeal, sir, 2016. (27th February).
Item number 10.
It may please your lordship, my lord. In this appeal, the Sonor Court has been pleased to grant the interim order, that which was not granted by the honorable judge. I pray one thing, your lordship may direct for disposal of the writ petition with this interim.
All right.
No, sir. Your lordship may fix a date for disposal. Because the
Writ petition itself, sir. Why?
Yes, any day.
Yes, I'm
It's
not
only
saying
against interim order.
yes, writ petition may be disposed of.
Correct.
The date may be fixed because the
Correct.
pomp has remained closed from 27th October 2017.
Well, I want early disposal. I am not in favor of delay the matter because I am suffering.
All right. You say it is seen that the writ petition, civil,
A connected matter has come, my lords. 23182 of 2017.
That 23182.
23182 of 2017. From which the present writ appeal arises. At the interlocutory stage, still pending disposal. Paragraph. In that view of the matter, while directing that the interim order passed with this court on 9th November 2017, granting status quo as regards possession of the petrol pump in question to be maintained, to continue during the pendency of the writ petition. This court directs that the writ petition will now be listed before the roster bench of the single judge. On 3rd January 2023, neither of the parties will seek adjournment on that date. The learned single judge is requested to. Pleadings are complete in the writ petition?
Yes, my pleadings have been complete.
Yeah, since pleadings are complete in the writ petition, the learned single judge is requested to proceed with the writ petition on merits.
No,
and endeavor.
My pleadings have not been, counter affidavit has not been filed.
Yes, I have filed the counter affidavit. I have filed the counter affidavit.
Let me make it. 1 second.
Lords, I have filed
Yes, my counter affidavit has been filed. I will file the rejoinder. In the meanwhile, I'll file the
rejoinder will be filed in the writ petition before that date. No further time will be granted for that purpose. The learned single judge is requested to proceed with petition merits and endeavor to dispose it off as expeditious as possible thereafter.
Obliged.
The writ appeal is disposed of.
Item number 11.
May I please, Your Lordship? But challenging the order of single judge, my lord, appointment for Anganwadi worker, my lord. The Lordship kindly glance the read petition page 8, my lord. What is the advertisement, my lord?
Yes.
It is not, may permit to read, my lord.
Yes.
It is notified by the Women and Child Development of the government invite application for 7 posts of Anganwadi worker, Anganwadi Center and Bhubaneswar and nearby area, my lord. Nearby project area, my lord. On basis of which the applicant, the appellant has filed the application and she has been selected, and there was no objection. The objection period is over, on basis of which the appellant has been appointed, my lord, Annex 13, my lord. Her name is find place at place 28, serial number. Binapani Sahu, wife of Ashok Kumar Sahu, my lord. Record number 3. Then after, your lordship kindly glance, what is the view taken by in the appeal, my lord? Page 37. Lordship find it, my lord?
Yes, please.
May I permit to read, my lord? The Learned Counsel for Respondent Srimati Binapani Sahu, in his argument of the substance such, submitted the annexure 4 of the writ petition filed by the appellant before this honorable court on double petition number 7900 2010 does not indicate that the area of operation of the record number 3 AWC, as the area of operation of the center has been defined in the notification, resident of Nilakant Nagar having requisite qualification are eligible to apply. It is argued by the Learned Counsel that there are 3 notifications on the one enclosed at A of the area objection petition filed by the respondent and another 2 notifications enclosed here. There are 3 notifications, my lord. Enclosed by the appellant marked Annex 4, plus page 18 and 25 to 33 paragraph are available in the present case. Respondent number 3 has been issued with a resident certificate by the Tahsildar Bhubaneswar indicating the place of residence of a respondent Binapani Sahu. This present applicant, my lord, as Nilakant Nagar Mundasai Bhubaneswar. So this place of residence has not been challenged in anywhere, my lord. The selection committee has added to the valid process of selection. The appointment never questions the residence status of the Binapani Sahu before selection committee. She was a candidate for the said selection. Objection period was specified as the respondent has already been selected by the committee. After serving the procedure, her selection at the stage cannot be challenged as stated as well. At other parties is estoppel by the operation of law and estoppels to challenge the selection. The appellant being a candidate for the said selection did not object the residence or education status of the respondent as per the time frame given in clause 10 of the notification. She is to raise such objection afterwards that the law is after selection of AWC, my lord. page
So come to the impugned order, single judge's order.
my lord.
Impugned order,
Yes, yes, my lord.
page 14.
14, my lord. This court by dated such and such has directed the collector to submit the report with respect to the factual position of the locality of the house of the petitioner. In turn thereof, the collector has given the details report from its perusal. It is evident that there are so many Anganwadi sector in Nilakota number 1, 2. It is Nilakota number 3, and as such, decision was taken by the authority to earmark the center area in order to function Anganwadi center smoothly. The collector has given specific report that the petitioner is not resident in the center area. Hence, this court is of the considered view that the additional district magistrate has no error in passing the order against the petitioner, keeping in view that in the fact into consideration that the eligible condition provided in the guideline of dated such and such, wherein provision has been made to become eligible for engagement of Anganwadi worker for the candidates who are residing in the center area, my lord. My lord, as for the notification guideline, my lord, 2527, my lord, again, my lord, come to this notification, my lord. On the third line, my lord, on basis of the modification regulation by 147 dated 2257, interested women candidate are apply for the same in prescribed application along with the attested relevant copy, my lord.
No, but you have to be a resident of that area, sir. That is very obvious.
It was not
a
there.
resident of Nilakanta Nagar.
It was not there in the notification, my lord.
That everybody knows, sir. Please. Anganwadi center is only for specified areas, and you have to be a resident of that area to honor eligible to become be appointed as AWW.
My lord, the 3 notification, my lord. In the first notification, my lord, page 8, my lord, they have stated that Nilakanta Nagar 2 Mundasai is house from Rama Murmu and last house Nava Murmu, Nilakota number 3. In between, my lord, my residence is coming, my lord. And my lord, the notification itself says, my lord, that modified the regulation of modified the notification, my lord. The notification has been modified on basis of which I have filed application, my lord. Dated 257, my lord. And the judgment says that cannot be changed the criteria, my lord. Just I am placing this judgment, my lord, your lordship, 2015 volume 2 OLR 752. It says, my lord, Sasmita Manjari Das was state of Orissa. It is held, my lord, that any conditions.
We are not entitled to, obviously, we are not entitled to copy of the judgment.
My lord, I'm sorry, my lord.
And he is also not entitled.
No, my lord, I'm sorry, my lord.
Then after you give the book, you are also not entitled.
May I permit to read, my lord? So that is my lord. Any conditions?
So we can permit you to read, no problem.
My lord, I will supply.
No, we're not adjourning like this, sir. When you come to argue a case, the least you have to do is keep copies of the judgments ready for giving to the other side.
I may pardon, my lord.
And giving to 2 judges.
I pardon, my lord. I will pardon. Sorry.
Done. That's it. All right. Proceed.
Yes, my lord. So law says that any conditions stipulated in the advertisement, it is still to be followed by the authority, and no case it will be deviated, my lord. Here, my lord, the subsequent paragraph, relevant paragraph is, it is held that from perusal of the advertisement, there is a condition that after receiving application forms, verification of original certificate and testimonies are to be done on 10/6/10 in presence of the applicant, and name of the eligible candidates will be enlisted and published in the notice board of block development office, notice board of concerned Gram Panchayat, and also published in village level. If any objection pertaining to the residence education qualification, caste or other certificate regarding the selection candidate be submitted before the CTPO after 7 days of publication of the selection list, that is 22/6/10. The selection committee shall ensure and investigate the objection within 7 days except holidays, that is 29/6/2010, or receiving the same if no objection is received by the office within 7 days as stated above, then it would be presumed that the selection list is just and proper, my lord. This is the law says, my lord. They cannot deviate, my lord. So as for the publication itself, it shows that it is modified the order 25/2007, what the learned individual has also held, my lord. It's not permissible in this case, my lord. So this appeal may be.
The present appeal is directed against an order dated 9th November 2017, passed by the single judge. In writ petition civil numbers 15010 and 1315/2011. Declining to interfere with the order passed by the additional district magistrate on 16th August 2010, setting aside the appointment of the appellant as Anganwadi worker bracket AWW in respect of the Neelakanta Nagar dash Roman Anganwadi Center bracket AWC. Paragraph. The background facts are that pursuant to an advertisement issued on 10th December 2009, both the appellant and respondent 5 applied for the post AWW at the aforementioned AWC. Stop. The appellant was apparently selected and given the appointment. Stop. Respondent 5 first filed a writ petition in this court in which an order was passed on 5th June 2010, directing her to file an appeal. Stop. The appeal filed by respondent 5 was allowed by the ADM Bhubaneswar by the aforementioned order, essentially on the ground that the appellant was not a permanent resident of Neelakanta Nagar 3, therefore was ineligible to be appointed as such, as an AWW at the said AWC. Paragraph. This order was challenged by the appellant before the learned single judge in writ petition civil 15010 of 2010. Stop. As is evident from the impugned order dated 9th November 2017, during the pendency of the writ petition, the learned single judge called for a report from the collector by an order dated 27 July 2016. Stop. The collector submitted a detailed report pointing out that Neelakanta Nagar 3 was earmarked for a separate AWC and that the appellant was not residing in the area of Neelakanta Nagar 3 AWC. Stop. In view of the said report, the learned single judge declined to interfere with the order of the ADM. Learned counsel for the appellant submitted that the advertisement issued for the post did not specifically mention the requirement that the candidate had to be a permanent resident of Neelakanta Nagar 3 AWC. He submitted that since no objection had been filed within the stipulated period to the candidature of the appellant, her selection ought not have been interfered with. paragraph. The guidelines for appointment of AWW prescribe the requirement of a candidate having to be a permanent resident of the area which is served by the AWC in question. Also, the fact that the advertisement may not have mentioned it will not permit the authorities to dispense with such a requirement. This is known to all applicants who apply for these posts. Full stop. Paragraph. Factually, it has been found by the learned single judge on the basis of the report of the doctor that the appellant is not a permanent resident of Nilakantanagar 3 area. The appellant has not been able to show that the said report is erroneous. Full stop. Consequently, the court is unable to find any error having been committed by the learned single judge in declining to interfere with the impugned order of the ADF. Paragraph. It may be noted here that by the same impugned order, the learned single judge disposed of the connected writ petition civil number 131 of 2010, directing the authorities to conduct the selection process afresh. Full stop. It must be noticed here that while admitting the present writ appeal on 5th February 2019, this court had stayed the operation of the said impugned order. Full stop. With this court now concluding that there are no grounds to interfere with the impugned order, the aforementioned interim order is with. The writ appeal is dismissed, no orders is to cause.
My lord, pardon, my lord. My age may be considered, my lord, so that I can, is a fresh list will come, your lordship. I will also participate in the.
We don't know, sir. Right.
But because I have, my lord, I have Udo, my lord, and where I will go, my lord,
All right. All right.
The age may be relaxed, my lord, so that I can participate in the.
All right. Thank you. None appears to be appellate dismissal.
Lordship, in this writ appeal, there have been certain submissions, written submissions given earlier, Your Lordship. But while I prepared it for the finally, I have given a total compendium for Your Lordship's appreciation.
All right.
Here, the subject matter is, Your Lordship, it is a case of VRS taken by the respondent employee. There are 27 writ petitions and consequential appeals, Your Lordship, here. This is the first case where all the facts are on record, Your Lordship. The other writ petitions will only follow suit, or writ appeals will follow suit, Your Lordship. Whatever will be decided here, it will be decided in all the cases, Your Lordship. It's a common case, Your Lordship. And a common judgment, one judgment, Your Lordship. Your Lordship, here, Your Lordship, may I place, Your Lordship?
Yes, please.
The judgment dated 11/4/2018 of the Honorable Single Judge, giving out directions superseded DP guidelines relating to VRS, is under challenge in the present appeal. 6/2/1990, respondent number 1 joined as senior porter cum page boy, grade 3 in the appellant number 2 hotel, a joint venture unit of ITDC and OPDC. This hotel is at Puri, Your Lordship, Hotel Nilachal Ashok, adjoining Raj Bhavan, Your Lordship.
I see.
7/1/1997, there has been an office order regarding revision of pay scale with effect from 1/11/1996. That is at serial number 1 to memo dated 23/8/2017 in the writ petition, and which I have enclosed as enclosure 1 here to this compendium. So kindly have a look at that enclosure 1 here. 7/1/1997.
Yes.
The management of Utkal Ashok Hotel Corporation Limited is pleased to revise the scales of pay of employees of Hotel Nilachal Ashok Puri who are placed in regular scale of pay with effect from 1/11/1996 as per detailed statement. And Your Lordship, the existing pay scale is there and the revised pay scale is there. And thereafter the enclosure that this next document is that which employee will be entitled to what scale and what the benefits, Your Lordship. This is undisputed, Your Lordship. And then, Your Lordship, following that, 7/2/1997, there has been office order regarding revision of all regular employees in line with the office order dated 7/1/1997, which Your Lordship finds at enclosure 2, Your Lordship. Well, 7/2/97, Your Lordship. This is an individual letter, Your Lordship, fitment order. And this Rabindranath Sahu is the writ petitioner here, Your Lordship. That's why I have given it, Your Lordship. And Your Lordship, then January 2004, hotel operation at the Puri ceased completely, Your Lordship. From January 2004, it has been inoperative. There has been no operation thereafter, Your Lordship. But the employees continued to the pay and the salary because of this situation, because the matter was pending here in another writ petition, and on the order of this honorable court, they have been paid their salary, Your Lordship. There is no dispute over that also. Then 19/5/2009, WPC number 39 of 3908 of 2015, followed by WPC number 2174 of 2011 for running the hotel operation, which were disposed of on satisfaction by this honorable court regarding payment of arrear and current salary to employees, as well as on being released under VRS. Because 17/8/2005, when the second writ petition was disposed of, there at that point of time, the employees had been released on VRS, Your Lordship. Then 5/5/2000, 8/12/2000, 6/11/2001, and 28/2/2002. These are 4 DP guidelines, Your Lordship. On VRS, Annexer 5 to 8 at pages 28 to 37, which I have also enclosed as enclosure 3, Your Lordship. Then 26/10/2004, another DP guideline regarding payment of ex gratia amount for CPSC employees following CDA pattern of pay scale.
CPSE. CPSE.
Yes, Central Public Sector Undertaking, Your Lordship. CPSE.
Enterprise.
Enterprise, I'm sorry. Correct. Thank you. Central Public Sector Enterprise, Your Lordship. And CDA is, Your Lordship, Central DA pattern, Your Lordship. There are 2 patterns, Your Lordship. One is CDA pattern, that is Central DA pattern, and another is IDA pattern, which I have also explained in my counter, Your Lordship. IDA is Industrial DNS allowance, Your Lordship. IDA pattern. And is changed every 10 years, Your Lordship. 86, 96, and 2006, and now 2016, Your Lordship. These are the 10 years, Your Lordship. And IDA pattern, Your Lordship, is changed every 5 years. It was changed before 5 years. 82, then 87, then 92, and thereafter from then 97, Your Lordship. Thereafter it is 10 years, Your Lordship. They have compiled it with the CDA pattern. So every revision will be 10 years, Your Lordship. Right. Now, this particular 26/10/2004 guideline, Your Lordship, that they say that the CDA pay scale at 1186 level to be settled at 50% supersession of earlier guidelines, Your Lordship. Earlier guidelines means these 4 and the previous one, whatever, this was restricted to only 50%, which is Annexer B to the counter at page 50, which I have enclosed as Annexer 4. And this particular document had not been given by the writ petitioners, Your Lordship, in the writ petition. It has suppressed. I have stated that they have suppressed it. Now, 22/1/2011, notice was given to all employees to offer their written willingness, unwillingness to join a new management, because at the relevant point of time, the hotel was supposed to be leased out to a private enterprise. And there the writ petition was also continued thereafter. But that was willingness and unwillingness are called for from the very employees, Your Lordship. And it was on 22/1/2011, which is at Annexer 1 at page 17 of the writ petition. Nobody responded, Your Lordship. Then, Your Lordship, came 25/3/2011, paper publication notifying all employees of the hotel to submit written unwillingness, Your Lordship. There are willingness and unwillingness. Here it is only unwillingness, Lordship, to serve the new management and to opt for VRS as per DP guidelines of the Government of India. So this is Annexer 2 at page 18, which I have also enclosed here as enclosure 5, Your Lordship. Then 2011, respondent numbers 1 and 28 other employees having applied for VRS stood relieved with effect from 8/6/2011 and were also paid VRS amount by the management. That is Annexer 3 at page 19 of the writ petition and Annexer H to the counter at page 72-73. Then, Your Lordship, there are 4 representations, Your Lordship: 8/6/2011, 12/8/2011, 11/9/2012, and 14/5/2013. Respondent number 1 wrote to the hotel management to increase basic salary at the rate of 100% for calculation of ex gratia under VRS, besides making out other claims. I'll stop here for a moment, Your Lordship, because at the time of VRS, Your Lordship, since 2004 notification was in vogue, which I have submitted at page 50, and that annexer enclosure 4, Your Lordship. That is why the calculation was also made as per 50% ex gratia was granted, Your Lordship. And they claimed that we should be paid 100% as per the DP guidelines, which was superseded. That, Your Lordship, finds enclosure 6. Lordship. Yes. Yes. Lordship, enclosure 6, Your Lordship. Your Lordship finds this is dated 14th May 2013. Kindly refer to our earlier letters dated so and so on this subject, wherein we, all the ex-employees of Nilachal Ashok Puri, had appealed to Your Honor to kindly look into our grievance, which is lying unsettled since long, as regard to settle our VRS dues as per the guidelines of DPE. It may not be out of place, Your Lordship may kindly mark this, it may not be out of place to mention here that at the time of finalization of our VRS, we were on the old pay scales, that is, 4th pay commission and not the 6th pay commission. This 4th pay commission relates to the CDA pattern of, I'll take a lordship to that. And as per DP's OMs dated 12/4/93, 17/1/94 and 19/7/95, if the executives non-executive scales of pay have not been revised since 1/1/92, then they are entitled to 100% increase on their existing pay scales. But our VRS was calculated on the pre-revised scale of pay and no increase of 100% on pay scales was given. Lordship, this is the prime attack here, Lordship, because other things I will also take, because the other correspondence are there. And here, Your Lordship finds the next page, that is 25/4/2015 to 30/4/2015. Consequent upon fresh notice published in the newspaper, all residual employees, 23 numbers, were relieved on payment of due VRS amount. Your Lordship, I may just suffice it to say that there were 52 employees on roll of the Nilachal Ashok Hotel, Your Lordship. First lot, Your Lordship, 2011, 29 employees opted for VRS. So they were released on 25/8/2011. Subsequently, Your Lordship, for the balance employees, another VRS was also floated in 2015, Your Lordship. And they were released 23, so it became 0, Your Lordship. Employee 0 it became. And they have released, there is no dispute from their side also with regard to this, Your Lordship. And Your Lordship, which I have already filed at Annexer A to the counter. Upon notice received from this Honorable Court in 27 writ petitions filed by individual VRS optees of 2011, the appellants filed counter and subsequent affidavits with supporting documents negating the claim of the respondent number 1. Your Lordship, 29 employees opted for VRS, but 27 are before Your Lordships. Your Lordship. 2 did not file any writ petition, Your Lordship. Then I have filed a, which I also submitted as Annexer F. Chart showing CDA pay scales of different pay commissions, Annexer F at page 66, Your Lordship, and enclosure 7. Your Lordship may kindly have a look at enclosure 7. This forms a part of the writ petition, Your Lordship, document, Your Lordship. Your Lordship finds that first lot is that 4th CPC pay scale with effect from 1/1/86. That is the first, second column, Your Lordship. Second column. Thereafter, Your Lordship, the 5th CPC pay scale with effect from 1/1/96. And last is that 6th CPC pay scale with effect from 1/1/2007, and thereafter it is 7th CPC 1/1/2016. We are not concerned with 5th, 6th, and 7th because they had been granted this 4th CPC pay scale, which they have themselves admitted in that representation which I read out before Your Lordship at page enclosure 6, Your Lordship, enclosure 6, which I had already read out. That is their admission, Your Lordship. Now, Your Lordship, this 11/4/2018, the judgment has been passed in WPC number so and so and batch of cases directing the appellants to pay through the respondent employees 50% further ex gratia, recalculate VRS amount on 26 days per month basis instead of 30 days, and 1 month salary as notice pay, which are all the existing DPE guidelines as appearing on record of the impugned case. Then Your Lordship finds I have remembered the submissions. The Honorable Single Judge, while detailing the facts as above said in the impugned judgment, has committed evident error in the concluding portion by directing payment of the additional amount such as further 50% ex gratia to the claimant respondent, besides recalculation of the ex gratia amount on 26 days a month instead of 30 days a month, and 1 month salary towards notice pay with least reasoning. Besides all being against DP guidelines forming part of the case record. Undisputedly, the claimant respondent had laid stress on calculation of VRS amount as per DP guidelines dated 5/5/2000, 8/12/2000, 6/11/2001, and 8/2/2002, and claimed 50% extra ex gratia amount besides 1 month notice pay, while accepting receipt of 50% ex gratia amount already paid to him. Respondent number 1 has suppressed the revised DP guidelines dated 26/10/2004. Showing admissibility of VRS ex gratia amount by 50% only and not 100% in respect of employees in CPSEs following central dearness allowance pattern of pay scales. Between CDA pattern of pay scale and IDA pattern is clarified in the counter affidavit at page 8 at page 46. Yes, page 46, para 8 at page 46 and 47, and further at para 8 of the additional affidavit at page 54-55, supported by annexes D, F, and G to the additional affidavit. Besides, respondent has also admitted to be in the 4th CDA pay scale by his representation at enclosure 6. Honorable Single Judge has ignored the said vital facts and documents, which has resulted in the erroneous finding at paras 22 and 20 judgment. Appellant establishment being a CPSE, as evident from annexer D to the additional affidavit filed by the appellant at pages 60 to 64. These are the answers made in the Rajya Sabha relating to the status of the Hotel Nilachal Ashokya. These are admitted records, cannot be disputed. We have already placed that. The fee appreciation order of 1997 at par with 4th CPC pay scale at pages 66 to 71 of the additional affidavit is not denied, but has been admitted and acted upon by the claimant respondent. Honorable Single Judge, having failed to use that vital fact, has arrived at an erroneous finding that the appellant failed to prove that the employees are members of CPSE and they were drawing CPSE salary and central DA. The Honorable Single Judge in the initial portion of the impugned judgment has reflected the import of the respective guidelines supporting the respective claims of the parties and framed the sole point for consideration as at para 13. That is, whether the ex gratia payment and other benefits under the scheme have already been paid to the petitioner. While in the succeeding paragraph of the judgment under the heading discussions, extracts of the different guidelines have been placed, relevant portions for the correct decision of the list have been left out. Similarly, in many of the paragraphs, erroneous and findings have been made by the Honorable Single Judge, notwithstanding facts and documents have been appropriately placed by the appellant. Therefore, the observations of the Honorable Single Judge in paras 21, 22, 25, 26, and 27 of the impugned judgment are not only contrary to the facts and materials on record, but also are otherwise unsustainable in law. The Honorable Single Judge, without considering the effect of the averments of the appellants in the counter and other affidavits read with the concerned documents placed at annexer D, F, and G, has come to a fallacious finding that the petitioners are not CPSE employees with CDA pattern of employment, but were governed by the state government pattern. The same has made out a case distinct from the claim of the respondent in enclosure 6. The Honorable Single Judge, without in the least considering the total effect of the DP guidelines as on vogue on the date of release of the employees on VRS in 2011, has come to an abrupt summary in paragraphs 28 to 30, granting all the entitlements of the claimant respondent, which appear to be contrary to the guidelines quoted at pages 11 and 13 of the impugned judgment. Evidently, claim of the respondent pertains to ex gratia at the rate of 100% notice pay and calculation of daily salary on the basis of 26 days a month as indicated in annexer. In response, annexer J to the affidavit dated 8/1/2018 was filed on behalf of the appellants in compliance with the directive of the Honorable Single Judge dated 28/11/2017, specifically referring to the statement of claim by the claimant respondent as at annexer 9. While the following submissions were made on behalf of the appellant, Honorable Single Judge has failed to consider same in the right perspective. 1. Payment of gratia at the rate of 50% is strictly in terms of annexer B, that is guideline dated 26/10/2004, in modification of the previous guidelines. Claimant respondent is not in notice pay since his notice period pay lapsed by completion of the period after submission of VRS application and its acceptance 8/6/2011, that is 2 months after. Further, the claimant respondent having drawn full salary during the notice period, further notice period pay is inadmissible as specified in the DPA guideline dated 8/12/2000 at page 32 and paragraph 10(11) of the impugned judgment. The annexer 8 to the writ petition at page 36 and paragraph 19, page 13 of the impugned judgment. In the impugned judgment, the Honorable Single Judge has not considered the aforesaid undisputed position of the DPU guidelines while abruptly answering the claims in full. Your Lordship, we have produced two decisions reported in 2011. Your Lordship, may kindly come to the last para, Your Lordship, because the only decision which has been cited from the side of the respondent has been that 1995 one SSC 478, which relates to definition of joint venture. This is not relevant in this case at all. But here I have cited three decisions, and I have also given the copies, Your Lordship. This 2011 one SSC L&S 215, 2016 LLR 673, and the 2016 9 SSC 462, which reaffirmed that once VRS is accepted and payments are received, this same shall not be open for judicial review, Your Lordship. This is in all, Your Lordship. Now, Your Lordship, may kindly come to that impugned judgment. I will take Your Lordship to once again to those paragraphs relevant, which are relevant, Your Lordship. Your Lordship finds which I have stated in my compendium, page 8 of the impugned judgment, Your Lordship, para 13. Last para, Your Lordship. Internal page 8. That is the point for consideration. The main point for consideration is as to whether the ex gratia payment and other benefits under the scheme have already been paid to the petitioners. Next, Your Lordship, the discussion starts from para 14, Your Lordship. It is admitted fact that the petitioners were employees of Hotel Nilachal Ashok. It is not in dispute that in 2011, petitioners opted for their voluntary retirement and they were relieved from their duties having been paid the ex gratia at the rate of 50%. It is also admitted fact that the petitioners are governed under the VRS guidelines issued by the Department of Public Enterprises. Now, Your Lordship, thereafter the quotations have been there from the different guidelines, Your Lordship. Your Lordship, initially, Your Lordship, that 5/5/2000, which is stated in paragraph 15, subpara 2, Your Lordship, of the quotation, Your Lordship, extraction, Your Lordship. Enterprises which are financially sound and can sustain a scheme of VRS of their own surplus resources may devise and implement variants of the existing VRS cited in para 1 above. However, in no case shall be the compensation exceed 60 days salary for each completed year of service or the salary of the number of months services left, whichever is less. Salary for the purpose of VRS shall consist of basic pay and DA only and no other element, Your Lordship. Your Lordship then comes to page 10, Your Lordship. The next DPA guideline is 8/12/2000. Para 16, Your Lordship. Your Lordship, here, Your Lordship, they may come to subpara number 4, Your Lordship, of para 16, Your Lordship. Subpara number 4, Your Lordship. Can notice pay in lieu of notice and TA settling hometown and elsewhere to be paid to employees who have opted for VRS. This is 1 month stroke 3 months notice pay as per service may be paid. So and so TA is not in here, Your Lordship. Now, Your Lordship, 8, Your Lordship, whether PF, leave encashment, gratuity, notice pay are payable to employees in case of voluntary department. These are to be paid to the employees opting for VRS as per the provisions of the relevant statutes and the service conditions. These are outside the computation of ex gratia and voluntary retirement. Now, the next is, Your Lordship, para 14, subpara 14, Your Lordship. This is important, Your Lordship. Whether the notice period pay is to be paid in addition to 60 months salary as compensation in case an employee has completed 30 years of service, then the remaining period of service is 7 months. Your Lordship, may come to the second subpara, Your Lordship, in the circumstances. In the circumstances, Your Lordship, where the management takes time to take a decision about the acceptance of an application submitted by the employee for voluntary retirement and allows the notice period to lapse, or the individual concerned has drawn full salary during the notice period served by him. In these cases, notice period pay would not be admissible as the individual has already drawn the salary during the notice period. This has been not been considered in the impugned judgment. It's very clear. Now, your lordship, then the para 17, your lordship, this is relating to the pattern of computation of 1 day's salary, your lordship. Your lordship finds the last, the note for computation of 1 day's salary, 26 days a month is taken, your lordship. That was decided there, your lordship. Now, your lordship, in the subsequent DP guideline, that is 6/11/2001, that is at page 12 and para 18, your lordship. The government have decided further to modify with the immediate effect the revised voluntary retirement scheme for central PSUs introduced by this government OM number dated 5th May as under. Then your lordship finds ex gratia payment. Here the question is ex gratia payment in this case. Ex gratia payment in respect of employees on pay scales at 1,187 and 1,192 levels. Your lordship, may kindly pause for a moment. These two relates to the idea scale of pay, your lordship. That is not the case here. Well, CDA. Ours is CDA.
Yours is CDA.
I couldn't get you. CDA. Yes, obliged. And computed on the existing pay scales in accordance with the extant scheme shall be increased by 100% and 50%. That means if it is 1,187, it will be 100%. If it is 1,192, it will be 50%. This is the next and this one. And your lordship, C, your lordship, may kindly have a look. This salary under the Gujarat pattern, because there your lordship had found the previous place, it was 26 days a month. And this says the salary for VRS basis shall be calculated on the basis of 30 days in a month and not 26 days. The judgment, impugned judgment has granted me to pay at the rate of 26
30
days. No, 26 days. I have paid 30 days, your lordship. But by the impugned judgment, they say that you have to pay on 30 days basis, your lordship. Just I'm sorry. I get it. Smile. Sorry.
All right.
Coming after so many years, my brain also little.
No.
I'm sorry.
Yes.
Your lordship is corrected.
Right.
Yes. The salary VRS shall be calculated on the basis of 30 days in a month and not 26 days.
Yes.
Consequently, the method of calculation of ex gratia for VRS and VSS shall be similar. And your lordship, then the para 2, your lordship, all other provisions given in the DP guidelines dated 5/5/2000 have to continue. Then clarification given in the DPOM of even number, that 8/12/2000, that is 26 days and 30 days relating to that, stand modified in consequence of the foregoing, your lordship. Then your lordship, because this doesn't apply, because you have already been released by the PSUs, that by the time this case has not come, your lordship. Then your lordship, another guideline on 28/2/2002, your lordship, which is at page 13, para 19, your lordship. Your lordship, again, it is clarified whether compensation of VRS 26 days a month would be allowed even for VRS optees who have gone out before 5/5/2000. This, of course, this situation is not required here, but they have clarified that it can only be 30 days. It is not required, your lordship. Then, your lordship, yes. Then 26/10/2004. This is para 20, your lordship. The latest guideline, your lordship. This is a further modification in the revised voluntary retirement scheme. Payment of ex gratia amount under the voluntary retirement scheme in respect of employees in CPSEs following central dearness allowance within bracket CDA pattern of pay scales at 1,186 level, computed on their existing pay scales in accordance with the extant scheme of VRS shall be increased by 50%. All other provisions of the DP guidelines dated 5/5 and 6/11/2001 shall continue to be operative. This relates to other than ex gratia, lordship. All other guidelines other than ex gratia, lordship, and CDA pattern, your lordship. Idea pattern will continue, your lordship. They are not defined that, your lordship.
No, but I thought your submission was that this was not relied upon by the single judge.
Yes, your lordship. Your lordship. I am taking your lordship to that. Yes. Then your lordship comes to.
No. So you are saying that they are entitled to ex gratia at 50%.
Yes. 50% has been granted to them, but the direction has been to pay at 150% more you pay. That means 100%. Your lordship, the last observation which the Honorable Single Judge has made in the last, hence it is imperative to note that after page 15, your lordship.
Yes.
After 2004, the ex gratia payment was made available to the petitioner employees who were already in service in 2004, but allowed to go on VRS in 2011. After 2004, they are only paid by increase of 50%. The Honorable Single Judge believes that since they have been this operation, the inoperation of the hotel establishment was in January 2004. They had to revert back to 2004, what it was earlier, prior to coming into effect of 50%. So 100% is to be paid. That is the imperative meaning, Your Lordship. Your Lordship, a middle portion, Your Lordship, but it appears from the further modification in the revised VRS that payment of ex gratia amount under VRS in respect of employees in CPSs following central DNS
So till you relieved them on 8 June 2011,
11 years.
You were paying the full salary.
Yes.
Oh, I see.
Yes, Your Lordship. Till 8/6/11, they have been paid all salary.
So the VRS took effect only from 8/6/2011.
11. Yes. Yes. 8/3. Yes. Your Lordship.
And they waited for 5 years to file a writ petition. I see. No explanation of the delay in filing the writ petition. Oh.
Then
Yes.
this, Your Lordship. Yes. Yes. So the question, Your Lordship, finds that last 3 lines of that page, para 21, Your Lordship.
Yes.
So the question of 100% or 50% as per wage revisions in 92 or 97, now merged only kind of payment basing on the pay scales on 1 and 86 does not arise. It is reiterated that all the petitions were only granted VRS in 2011. This is the confusion, Your Lordship.
No, and I think even this sentence, bottom of page 22. Here, learned counsel petitioner submitted.
Para 22.
Yeah, last 3 lines of
yes,
page.
Yes, Lord. Submitted that the petitioners are not paid with the central DA, but are paid industrial DA.
This is wrong.
That is wrong, Your Lordship. In view of their admission, Your Lordship.
Yes.
On the other hand, land counsel for the opposite party submitted that the petitioners are guided by the payment of central DA, but not the industrial DA. In the writ petition, it is admitted that the petitioners have claimed state patron pay and the additional DA, whereas opposite parties admitted to have been paying state government pay, but not awarding any DA there too. This is completely wrong. Yes.
Correct. Yes. Because you are admitted to paying only central government.
Yes, CPC. That has been granted, and they have accepted that also since 1986 onwards. When the opposite parties are saying that guideline of 2004 was applied, it has to prove that the petitioners are not only members of CPSs, but also they are drawing the central DA. No document has been filed by the opposite parties to prove its case. I'm sorry, Your Lordship. Then, Your Lordship, the decision is cited, which is not relevant, Your Lordship. Then, yes. Now, Your Lordship may come to page 25, Your Lordship. I'm sorry, page 17, page 25, Your Lordship. Para 25. In the counter affidavit of the contesting opposite party, while admitting about the joint venture, they have submitted that persons being CPSC employees are getting central DA. Assuming for the sake of argument that the petitioners were receiving central DA, it is not clear from the calculation sheet that they were paid central DA. The contesting opposite parties have not placed any document to show that the petitioners have been paid CPSC salary, and it is for the employer to show as to how the petitioners were being paid salary and how far the guideline of 2004 will apply. But it is reiterated that the owners of the opposite parties has not been
No, so what is the single judge saying? That you have not placed pay slips to show that CPSC was being paid or CDA was being paid?
Your Lordship, that admission is there, and these pay scales which have been revised with from 1/11/96, that is only CDA pay scales, which they have admitted, Your Lordship. And they have also given a particular statement in which they have admitted, and we have also given the statements. Our statement. And not inclusive. We have given a statement, but we have given that is already there on record. And Your Lordship finds on the very next page that para 26.
No, with your counter affidavit, you must have placed some material on record to show they were being paid CPSC as CPSC employees.
Yes. That I have stated, Your Lordship, which I have appended to this compendium. They're all there, a part of the counter affidavit only. And I have stated what is CPSC pattern and what is IDA pattern. I mean, what is CDA pattern and what is IDA pattern. I've also explained. Your Lordship, again, kindly have a look. Written. Para 8, Your Lordship. Page 46 and 47 and 54 and 55 of the writ petition, Your Lordship. I have placed page 46, 47. Yes. Your Lordship, it starts with that it will not be out of way to submit, Your Lordship. Page 46, para 8, last 2 lines, Your Lordship. Yes. It will not be out of way to submit that in the central DNS allowance pattern, revision had taken effect for every 10 years. That is from 1186, 1196 and thereon. Whereas this effort at 1187 and 1192 pertains to the IDA pattern wherein revision was affected in 1187 and after 5 years on 1192. The DP guidelines speak about each individual PSU, PSC making its theme, and as such, no illegality or discrimination can be alleged in calculating the amount for a month of 30 days and not 26 days as unjustly claimed by the petitioner. The claim for increase of ex gratia compensation of 100% cannot be sustained via the modified DP guidelines of 2004 as stated here. As per one notice pay were not on notice pay. So this is clear. Then you will say 54, you will say, kind of have a look at 54. Well, again, para 8, you will say 54, para 8, you will say. Your Lordship gets it. As has been stated in the counter affidavit, which has not been in any way controverted, but it is reiterated that the petitioner was on CDA pay scale, which appeared to be at par with the pre-existing state government vis-a-vis central government pay scales, but the said pay scales continued to be at 1186 level. By way of clarification, it is stated that the petitioners and other similarly stated employees were in receipt of the revised pay scale of the 4th pay commission as per 186, which was also applicable to the state government employees. Even though the pay band of the grade pay pertaining to the erstwhile grade and pay scales of the central and state government are revised from 1196, 2006 and 2016 respectively. Yet the case of the petitioners remained as such. It will not be out of place to state here that the government of India used to revise the scale of pay and allowances by institution of the central pay commissions, usually at an interval of 10 years. Consequently, the state governments, including that of government of Odisha, have rationalized and revised scale of pay and allowances of employees of the state government basing on such recommendations of the pay commission set up by the government of India. So, these are the particular things with regard to the different. I'm sorry. And so, Your Lordship may find we have also given.
There's no reference by the single judge to these pleadings.
Yes. And Your Lordship, in that annexer F also, there is a table which I have given. Yes, Annexer F we have already given to them. Annexer F you have already stated as enclosure 7 to this compendium, Your Lordship. That shows the different pay scales and from different years, Your Lordship. And which simply just pause for a moment and remember, because their representation is that we have been getting CDI pay scale of 1186. You kindly, since we have retired in 2011.
Now apply 6th and 7th pay commission.
Yes. That is there.
All right.
My Lordship.
Yes. We'll hear that.
May I please? Your Lordship, kindly have a glance at Annexure C or page 18 of the judgment, Your Lordship.
All right.
The entire issue is based on whether Hotel Nilachal Ashok is a CPSC or not. First issue. So at page 18, Honorable Judge has also it is clearly is mentioned that a bare perusal of the memorandum dated 25/8/1987 by Annexure C, which was also produced by my learned senior, and also I have also placed in the record in the petition, shows that Hotel Nilachal Ashok Puri is a joint venture project of ITDC and State Tourism Development Corporation, and they have adopted the state government pay pattern.
Where do you get that? That's the whole problem.
Yes, that is Annexure C of the counter affidavit.
Let's see that.
Annexure C.
All right.
My place, let's see.
Yes.
So this is of the ITDC manager Hotel 2 VP, senior VP ITDC 2 manager Hotel Nilachal Ashok Puri. Please refer to the letter number such and such dated 13/8/87 addressed to general manager such and such. Last paragraph. The Hotel Nilachal Ashok Puri is a joint venture project of ITDC and State Tourism Development Corporation, and we have adopted the state government pay pattern. So ITDC himself is saying we have adopted the state government pay pattern. As such, for the present state government's medical rules in regard to reimbursement of medical expenditure may be followed in respect of ITDC, even for the ITDC officers who are in deputation. So because the Hotel Nilachal also is coming under the joint venture of the ITDC and state government, and they have adopted the state government pay pattern for the employees, the deputed officers will also get the medical expenditure up as per the state government. First issue, if my learned senior is submitting, if it is a central public sector enterprise, whether a public sector enterprise will pay the employees state government pay scale. First point, your lordships. To that effect, your lordships, but my learned senior also pointed out that in the previous date chart, your lordships, today I have received the fresh date chart. The previous date chart submitted by my learned senior, that written submission come date chart, your lordships.
Yes.
It is admitted fact that the respondent number 1.
Where are you reading?
First page, your lordships. January 2004, hotel last date. January 2004, hotel operation at Puri ceased completely. Actually, it is a wrong fact because the respondents were working till 2011.
No, the hotel operation ceased.
Yes,
that's the point he was making.
Yes.
He says, although the hotel ceased, you were getting your full salary till 2011. 8 June.
To that point, I will come, your lordships. First, I will clarify that the petitioners were not getting the central government pay scale. First point, it was their memorandum, office memorandum. Second point is the OJC number 14284 of 1997. It was filed. It was also discussed in judgment also. (14287) of OJC number 14284 of 1997 was filed only because what my learned senior is submitting, the pay was revised. But actually that pay was not revised. Only that was a 15% hike of the salary, for which was that office order on 1/1/1997 was never implemented, and the employees were filed OJC number 14284 of 1997. After that, into 15, that 14287 of 97 and other petitions were withdrawn because of the false submission of the ITDC, because in 2015, the rest of the employees when filed the writ petition for their accommodation,
yes.
In my date chart. Sorry, your lordships. Yes. Respondent number 1 got an offer for appointment at Hotel Nilachal also, which was confirmed with effect from 1/6/1990. It is admitted fact. In 1990, he was appointed. Some more employees were there also. They have got appointment in 1988, 87, 89. So this particular petitioner is respondent number 1 has got his appointment in 1990. And present appellants have filed affidavit that though existence of pay pattern in Hotel Natural Stock having remained undisturbed for about a decade, prayer for ITDC pay scale is unsustainable. In 14284 of 1997, the counter affidavit of ITDC shows that because the appellants, they have filed that because though existence of pay pattern in Hotel Natural Stock having remained undisturbed, it is admitted fact. In also writ appeal also they have stated that there is no revision of pay.
Correct.
It is admitted fact. So it is Hotel Natural totally unconnected with ITDC pay pattern. It is admitted and filed with the affidavit by the ITDC in OJC number 14284 of 1997, which was also discussed while we were arguing before Honorable Single Judge. So,
Just reading out from some page, where is it an admitted position? At least by the present appellant, where is it admitted that they were not getting ITDC pay scales? It's not an admitted position.
No. They have filed their affidavit before this honorable court in OJC number 14284 of 1997. Which was connected. It was filed by the employees union. And because these appellants were also there, and they have filed that because this Hotel Nilachal Aswak is totally unconnected with ITDC pay pattern. Again, 4144 of 2000 was filed, praying for a payment on the for OTDC pay scale, but that was also not paid. And in 2004, you will see they have created a situation of artificial closure, for which 3098 of 2004 was filed.
No, but how does this help you that this court asked them to pay you ITDC pay scales? And that was affirmed by the Supreme Court.
Yes.
So how does this help you? Because you are now trying to argue that what you were paid was state government pay scales.
Yes.
No, but isn't this at cross purposes? You're referring to a writ petition in which a direction was issued that you should be paid ITDC pay scales.
But that was not implemented. That is my point, Your Lordship. That was my prayer before this honorable court in this writ petition.
No. Did you file a contempt petition in that?
No.
3098 of 2004.
Up towards 3098, Your Lordship, SLP was filed, which was dismissed.
Correct. So if that required you to be paid ITDC, but according to you, it was not implemented.
Yes.
What steps did you take?
They increased only 50%. They hiked my salary. And because no salary was given to all the employees, showing that it is running, it is in a loss making, it is not a profit making institution. So we are under loss. So no salary was, full salary was not received by the employees. That is why when they afford the
VRS
not where they stated that because it will be sold out. So you file your.
No, but tell us this. Once you accept the VRS, forget all these arguments. Once you accept the VRS, how can you go back to the court and now say revise my pay scale and refix my?
No. I am not. I am not on the revision of the pay scale. I am not on.
No, but that's a prayer that you said. First of all, increase my ex gratia to 100%.
Because the DP guideline itself says.
Once you accept a VRS, once you accept a VRS package. Where's the question of going back and saying now increase my ex gratia?
My only prayer to that, Your Lordships, kindly have a glance at my date chart, Your Lordships. That short note of submission what I have given.
Yes.
The present appellant assured I have wrongly presented that stated the OP that actually present appellant. Para number 2, my short note of submission.
Yes.
The present appellant assured the respondent number to offer VRS as per DPE guidelines, the Government of India, but violated the same, paying no heed to the petitioner grievance for which writ petition was filed. The present appellant never disputed.
Actually, this is all vague because this VRS package was accepted in 2011. The VRS package was accepted in 2011.
Yes.
8611. You're not explaining after 5 years you filed a writ petition
Yes,
claiming
because-
that
Because in 2000, that is my point, Your Lordships. Kindly bear with me. The writ application along with 26 similar application was filed. Issues I have narrated there. But only point, Your Lordships, because why delay was there, in 2015, they have given me the 50% amount. But that is point I have taken in my writ petition, Your Lordship. Writ petition, because in 2015, I was paid 50%. After disposal of the 2015 writ application, that is 2174 of 2015, filed by 23 rest employees. After serving for 4 years, getting full salary for 4 years, they have opted VRS, and they were said that in the counter affidavit, ITDC is told that because other 29 employees have received their VRS and they are satisfied with that, that is why that all these petitions were disposed of. And after that, in 2015, 50% of ex gratia was deposited to my account. When I inquired about this amount and this breakup, ITDC told that this is 50% of your amount, and that also Annexure 9, I have submitted entire calculation, how much I was paid in 2015. That is why in 2016, I filed my writ application, saying that when I have paid for since 2011 to pay to the 100% of ex
no, there's a
gratia.
counter affidavit filed to this writ petition.
Yes.
Let's see what they say in that counter affidavit. In reference to para 13. There's no para-wise reply.
Counter affidavit. Yes.
See, they refer to the DP guidelines of 2004, 26/10/2004,
that
where it says that employees in CPSC following CDA
CPSC. First point, Your Lordship,
shall be increased by 50%. They say that is what applies.
Yes. If that is the whole point, Your Lordship, that is the crux of the issue.
Correct.
So 2004, I am coming to 2004 guideline, Your Lordship.
Yes. There is a judgment of 17th August 2015, is it? In 2174 of 2011?
Yes, yes. That is what is in 2174 that was filed by rest of the 23 employees.
So they
who were working since 2011 to 2015.
Yeah.
They didn't give their unwillingness to work under the new management. So they were working and they were getting salary. But in 2015, when these 23 employees who are not the petitioners here, the respondents, they filed that our service may be secure. Because now we may be permitted to accept this, whereas because in that writ petitioner, let's say, ITDC pledged that because 29 previous employees have already taken their entire VRS amount. Actually, it was not the fact. Because they were already taken their VRS amount, everything was paid. So in that light, the petition was disposed of. But these after 2015
See, I
judgment.
think what comes in your way is this 26/10/2004
Yes,
DPE
yes.
guideline.
Yes, yes.
According to them, this guideline
Yes, yes.
restricts the ex gratia to 50% for
Yes, yes.
CPSE employees following CDA pattern.
Yes.
So everything turns on this
No.
26/10/2004.
Yeah, I'm coming.
Next, B.
Let's see, kindly have a glance at page 36, Annexure 8 of the writ petition, where the this guidelines started. Annexure 8.
So that's a
Sir, sorry.
2002 guideline.
Yes, yes. Sorry. I'm coming to annexure. That is 2004. What is submitted by my learned senior.
Correct.
Parent of the counter affidavit.
Correct.
Yes. I may be permitted to place that, Your Lordship.
Yes.
This is further modification in the revised voluntary retirement scheme.
Right.
In continuation of modification wide OM number such and such dated 6/11/2001, Your Lordship.
Yes.
Kindly it be marked 6/11/2001. In the revised voluntary retirement scheme introduced for CPSE, Your Lordship.
Yes.
It is introduced for CPSE. But my first submission was before Your Lordship that whether I am a CPSE, no, because I am getting, I am under the joint venture, and in no way the Hotel Nilachal Ashok was getting the salary as per CPSE or central government pay pattern. It was clearly, it was stated and it was admitted by my learned senior that office memorandum was issued by ITDC to pay state government pay pattern to the only Hotel Nilachal Ashok. I am confined to Hotel Nilachal Ashok. I am not for the other ITDC hotel. Only for HNL. Only for Hotel Nilachal Ashok, they have opted state government pay pattern. Whether there is a central public sector enterprise can opt state government pay pattern. No. So it is central public sector enterprise by this document dated 5/5/2000. The government have decided to further modify the scheme with immediate effect as under. Payment of ex gratia amount under VRS is in respect of employee CPSE following CDA pattern of pay scales 1186 level. But 1186 level is not my case, because in 2000 and 2001 and 2002, it is not superseded, Your Lordships. Last line is saying that all the provisions of DPE guideline dated 5/2000, 6/11/2001 shall continue to be operative. So the employees who have already been released by the CPSEs before the, so this is only for central public sector enterprise, not for me. And what the earlier circulars, earlier guidelines were saying that it is first circular, that is annexure 5. It was only for it is on no specification of CPSE. It is only for the public sector enterprises. And page 29 also, employees of industrial cooperatives with government equity participation who are not members of cooperative will also be covered under that. Again, it is para 9 also, it was stated that page 29, VRS will be applicable to the permanent employees, bodily workers, work charge established, and temporary workers, but not to the casual. So even if the permanent employees are not there, they are also, this scheme is applicable. And the second one, that is 2008-12-2000, Again, the operative part is para 32 regarding notice pay, your lordships. Because the employees were not getting their salary, they had no alternative than to accept the amount when 8/6/2011 they were paid some amount. The salaries which was not paid since years, that was paid on 8/6/2011, no VRS amount. So it was because of the earlier rates will prove that they were not getting their full salary. There are so many writ petitions were pending. These were also referred in Malad Senior's date chart, earlier date chart, at my date chart also it was there. So that 87 level and 92 level was clarified in the subsequent guideline university. That was also taken care of by Honorable Single Judge in the judgment. In my date chart, page number 2, I have stated that DPE guideline dated 5/5/2000, government have revised the scheme to make it more efficacious, having regard to both the interest of employees and the need to enable public sector enterprises to rationalize surplus manpower. There is no specification for CPSEs. And page 10 and 11 of the judgment, where DPE guideline dated 8/12/2000 was also discussed. Para 4 also, it was stated that 1 month or 3 month notice pay may be paid. And para 14 also specified that if the employees have not drawn full salary, if the employees for the notice, then notice period pay would be admissible to them. And to that, enclosure was also attached to that guideline, and it was undisputed by my learned senior in this writ application also. The page 12 and 13, which is discussed at para 18 and 19 of the judgment, that 6/11/2001 guideline, your lordships, which clarified ex gratia payment in respect of employees on pay scales at 1187 and 1192. And 1187 will be paid 100%. 192 level will be paid 50%, which was clarified in the next guideline 28/2002. Any wage revision permitted by the PSCs for a period prior to date of effect from 1192, because the employee was joined in 1990 and somewhere in 1989 and 88. So they were prior to 1192. So they are coming under 87 level leaders, for which 100% ex gratia is applicable to them. And so far as 2004 guideline, your lordships, it is only provisions. This provision is only for the CPSE, your lordship. And my submission before your lordship is that I am not CPSE. Yes, your lordship.
Lordship, I will only answer 2 issues, your lordship, whether this is a CPSE or not, your lordship. Your lordship, kindly see my memo dated 8/8/2017 to the writ petition, where I have stated the Rajya Sabha questions answered in the Rajya Sabha, and where, your lordship, I'm sorry, 8/8/2017, your lordship. My lords, yes, Your Lordship. The question was asked in the Rajya Sabha, Your Lordship. Will the Minister of Heavy Industries and Public Enterprises be pleased to state whatever? Your Lordship, Nilachal Ashok, Utkal Ashok Hotel Corporation Limited, that is the Nilachal Ashok Hotel, Your Lordship. Hotel Nilachal Ashok. This is the employers, because joint venture name is Utkal Ashok Hotel Corporation Limited. That finds place at the bottom, Your Lordship, page serial number 78. My lords, CPSC, Your Lordship. CPSC.
So that also I have filed objection at that time also. My objection is also there.
Yes.
What about that memorandum she's referring to, the joint venture, it will be a state scale. She referred to her election.
Initially, Your Lordship, I have also indicated and also read out, Your Lordship, that initially the state government central pay commission, whatever it recommends, it is also accepted thereafter by the state government, Your Lordship. Same is being followed. Once it is CDA, the central of the pay, state government, they are following the same pattern.
That particular document.
Yes.
Where is that?
Annexure C, Your Lordship.
Annexure C.
C.
Counter Annexure C.
Yes.
This memorandum of 25th August.
Yes. And it's a C, Your Lordship.
Hotel Nilachal Ashok is a joint venture.
Just, Your Lordship. Page 59, Your Lordship. Yes. Page, Your Lordship. Yes. We have adopted the state government's pay pattern, Your Lordship. It is our document. We don't deny that, Your Lordship. But state government's pay pattern, Your Lordship, which I have indicated subsequently in this honorable court, that how the state government pay pattern and the central government pay pattern, once it became a CPSC, how it has been conglomerated, and thereafter the revised notification and revised scale of pay was given to them at par with the centralized pay scales, Your Lordship, which they have not disputed. Now my learned friend says that we are not on CDA. That is absurd, Your Lordship. Their own document is there that we have been getting the fourth, Your Lordship, that enclosure 6, which I have enclosed to this compendium today, Your Lordship, and which is also a part of at page 26 of the writ petition. It is there, Your Lordship. Their own representation. It may not be out of place to mention here that at the time of finalization of our VRS, we were on the old pay scales, that is on 4th pay commission. This is CDA. It cannot be idea, Your Lordship. And it is effective from 1186 pay scale, but it was given effect 196, Your Lordship. And what my learned friend says that they were not received any salary, Your Lordship, and they were paid only on 86. That is absolutely wrong, Your Lordship. Because in the relevant writ petitions, which I remember now, because some people, because it was not in operation, so there was difficulty in paying the day-to-day or the monthly salary to each of the employees. Thereby, the union came up before this honorable court to pay the up-to-date salary to the employees. And on the direction of this honorable court, the salary has been paid. And because the matter was carried to the Supreme Court, the honorable court also said, no, irrespective of till your final decision is taken, you'll have to go on paying the salary, whether it is or inoperative. That is how they got the salary from time to time till VRS was opted, Your Lordship. That is the position. That is not connected with the issue here, Your Lordship. The issue here is whether 2004 notification, DP guideline, whether the payment which has been made as per 50% ex gratia amount, whether that will be correct, or the previous guidelines which relate to the IDA pay scales, that is 87, 1187, 100%, it will be paid or not. This is the crux of the matter, Your Lordship. And may I take, Your Lordship, to the judgment, Your Lordship, how the
she was also referring to OJC number 14284 of 97.
That is exactly which I remember now, just I told, Your Lordship. That is relating to the union came up before this honorable court claiming.
But there the counter was filed by ITDC.
Yes.
Saying that Nilachal Ashok employees were not being paid ITDC. They're totally unconnected with ITDC.
No, that is, I cannot say now, because unless I check up that, I cannot now say. This is a fresh thing which has been told, but I don't know.
That was also tagged in the writ petition hearing, Your Lordship. Your Lordship can. Yes, it was tagged.
Anyway, but the whole thing is that we are not on ITDC or OTDC scale of pay. We are on CDA or IDA, Your Lordship. Because if we have to follow the 2004 guideline, whether it is CDA pattern or IDA pattern, Your Lordship. IDA pattern relates to the guidelines which were prior to 2004. And 2004 has amended the earlier one of CDA pattern, Your Lordship. And they themselves have admitted that we are on CDA pattern, Your Lordship. Fourth pay commission.
Only
just
one.
A minute. Let me finish.
Yes.
And your lordship sees in the judgment, your lordship, because that portion I have not taken your lordship to, because para 8. Okay. Wait. Yes. Your lordship, page 18, your lordship, of the judgment, your lordship.
1-8.
1-8, your lordship. And para 27, your lordship. No doubt. Starts with no doubt, your lordship.
Yes.
No doubt the aforesaid circulars of 2000, 2001 and 2004 are all related to ex gratia payment of IRS. On close scrutiny of the same, it appears that 2004 notification has been added to the guidelines of 2000 and 2001, but had not substituted the manner of ex gratia payment as mentioned in the guidelines of 2001. This is the wrong conception, your lordship. In the present cases, since the petitions are governed by the state government pattern, although the employees of joint venture, it cannot be said that they are receiving central pay dearness allowance. It is also clear from the guidelines of 2004 that except addition of such clause about payment of ex gratia, rest of the provisions of the guidelines of 2001 remained intact. In terms of the above discussion, it is clear that the petitioners have received ex gratia at the rate of 50%, but they have to get 100% ex gratia being coming under the guidelines of 2000 and 2001 with respective clarifications. It will not be out of place to mention here that the petitions are recruited in between 1989 to 1991, and thus they are eligible to get ex gratia at the rate of 100%. This is the conclusion, your lordship. And the second part is that so far as 1 month salary of the petitioners as per guidelines is concerned, the petitioners have not received this in lieu of 3 months notice period. So they are entitled to 1 month salary while taking VRS. But the guideline is completely contrary, lordship. If you have received the salary for the period of, or you have overstayed the period of notice, your lordship, then you will not be entitled to any further notice period pay, your lordship. And it is claimed by the counsel for the petitioner that VRS dues have been paid on the basis of 26 days a month, but not 30 days a month. On the other hand, the guideline of 2001 clearly shows that salary for the VRS shall be calculated on the basis of 26 days a month, but not 30 days a month. And 30 days is substitution, your lordship, thereafter. But the petitioners are entitled to VRS calculation on the basis of 26 days a month. So these are the 3 deductions, but not based on the facts or the documents, related documents which are on board, your lordship. That is how it has been answered, your lordship. And your lordship, there is, as I have said, that there are 52 employees. 52 out of 52, your lordship, 25 employees have already received and they have no dispute, your lordship. And this dispute relates to only 27. Good. Yes. And their representation, which is at enclosure 6, and pursuant to which they have filed the writ petition, your lordship, that is 14th May 2013, that is enclosure 6. They again say that we are on old pay scales, that is on 4th pay commission. Once they admit that we are on 4th pay commission, what is the 4th pay commission, which I have also stated as that enclosure 7,
1186.
1186. And they are demanding you should pay 5th and 6th pay commission. You should pay.
Or
yes.
Reserve orders.
Yes.
Will reserve orders. Anyway, your written submissions are there already.
Yes, sir.
Or orders reserved. This covers all the 28 appeals. Is it?
Your lordship, I'm sorry to say that on the last occasion on 27th October, 6 appeals were listed, but unfortunately that strike was going on, so we could not appear. We have filed already the CMA PLC, your lordship.
There's no strikes. There was
no, whatever. I'm sorry, sir, but it's not a strike, but we are prevented. We couldn't come. But the other cases are there today also at annexure 14. Item number 14, all the other rest of us are there. 20 matters are there.
All right, 13 and 14 orders reserved.
I'm sorry that I've taken a lot of time. Your RCB also is kind.
No, it's all right.
Item number 15.
In this case, the petition has said order annexure 6 test 1920 million. There is a 28 months delay to file this appeal, and the delay arose due to non-communication order to the petitioner. The case was like this: the petition happened as a home guard in 95, and he was a leave due to his mother was illness, and he in the meantime his mother was died. and she could not attend the duty, for which she was disengaged. But that is not communicated to the present petition. And the petitioner, after over the obscure ceremony, on the office joined but did not allow and so on to inform the commanded home guard, and home guard said that we were disengaged. But my submission is that one was notice and not issued prior to disengage. That is pertinent questions. And Annex 6, page 20 Miller, the Honorable Single Judge did not enter into the writ application and observe that constitutional submission made, I don't find it infirmity in the input data so as to warrant interference. My submission that when our statute and notice
Yes,
one was
unreasoned order is it? No reasons given
There is a delay of 1,000 days.
in filing this writ appeal.
Yes.
But delays come cut out yet.
No.
No.
What's the reason for the delay?
Sir, the previous content council could not intimate the.
Okay, we'll dismiss it on delay. You say IA 1334 of 2019. There's a delay of how many?
860 days. 860.
Oh, delay of 860 days in filing the present appeal. The reason given in the application for delay is only that the previous counsel could not inform the appellant of the outcome of the writ petition. The court does not find the explanation to be convincing. It was for the appellant to follow up on the writ petition and ascertain its outcome. Good time. Consequently, the court is not satisfied that there is any reasonable explanation for the inordinate delay in filing the appeal. The writ appeal is accordingly dismissed.
Item number 16.
Item 16. Before going to the merits of the case, I would like to submit that the petition is suffering the punishment, Department of Punishment, lower the basic pay by 5 stages in his incremental state. But he has retired since 4 years. Now he is a paralytic president. Can it be reduced to 3 so that he can get some benefits? He has suffered. Lower the basic pay by 5 stages in his incremental scale. If it can be reduced to 3, then he can get some benefits.
Who's for the opposite?
My lord, I am mapping. My lord, once annex page 14 and page 50, once it was reduced. It is a second round of litigation, my lord. In first round, it was reduced subject to lordships. One, my lord, again. You have already, appellate authority has already reduced.
No, it only has to go back to you for reconsideration.
No,
we cannot substitute.
Yes, madam.
No, so you better take instructions.
Yes. It doesn't.
Counsel to the appellant submits that the appellant suffers from a paralytic stroke and is bedridden, and that the punishment of reduction of his increments by 5 stages is too harsh. He prays that it may be reduced 3 stages. Stop. Counsel for the respondent one bank seeks time for instructions. And his request list on. 7th February.
Item number 17. Item 17,
None appears dismissed.
item number 18,
My lords, item 18, I'm sorry, can be taken up tomorrow. I have a wrong file. It has come.
Counsel for the appellant states that he has brought a wrong file to the court. List on 13th February.
item number 19,
None appears dismissed.
item number 20,
None appears dismissed.
item 21,
May I please your lordship, because this read appeal is filed against the order of honorable single judge and page 57 and order annexure 13. Milord, the read application was disposed of, directing the petitioner to.
So normally when we argue appeals, first draw attention to the delay in filing the appeal.
Milord, delay.
Just tell us how many days delay, sir.
Milord, prior the read.
Tell us the number of days delay first and then give us explanation.
Milord, initially one read appeal was filed with 7 days delay, and in subsequent period that read appeal was permitted to be withdrawn with permission to file a better application. And accordingly, this read application is filed.
Kindly tell us the number of days delay, sir. I won't ask you after this. Okay.
Milord, it is within time because the case was allowed to be disposed of, withdrawn by the order dated 30/4/19, and the case was filed within 30 days, Milord, 27/5/19. It is within time.
What is the date of the impugned order, sir?
The impugned order, against the impugned order, one read appeal was filed, Milord.
Sir, tell us the date of the impugned order.
Yes, Milord. The impugned order dated 10/11/17.
So obviously against a 10/11/17 order, if you file an appeal in 2019.
No, what happened? I filed a miscase seeking recalling of that order on annex.
The recalling miscase will not extend the period of limitation. Let's be very clear. Recall will not extend the period.
That petition for recalling was not allowed, dismissed, and accordingly I filed a read appeal with a 7 days delay, and thereafter that was permitted to be withdrawn for filing a better application.
So that 7 days delay could not have been from the original order, sir. 7 days would have been from the date of dismissal of the recall application.
The past appeal was filed.
Anyway, if you insist on arguing like this, you continue arguing.
No,
there's no difficulty. See, till now you've not answered the question we've asked you. The office has told us an answer. All right. We just want to cross-check with you whether you also are aware of the number of days delay, but you're in denial.
No,
it's up to you, sir. No difficulty.
No
problem,
I'm sorry,
sir.
I'm sorry.
Don't have to be sorry. You just don't want to acknowledge. That's all right.
Milord, the first read, Milord, your lordship may kind of see the original order which has been challenged before lordship dated 10/11/17. How gross injustice has been caused to this petitioner, your lordship may see the read application was filed in the year 2010. After issuance of notice, it was kept pending for long 7 years. After 7 years, the read application was disposed of, directing the petitioner to raise his grievance before the liquidator. Milord, against the order of liquidator, that read application had been filed. And to that very person, direction was made that you raise the matter before the very authority against whose order the read application was filed. After 7 years, the read application was kept pending, and thereafter this order was passed. When this order was passed, immediately this petitioner filed a petition saying the order be recalled and modified to the extent that because the person to whom direction is made to raise that very person against his order, the read is filed from the 2010. And it is pending since 2010 after issuance of notice. And the honorable single judge did not listen to that and said that you raise the matter before appropriate forum. And against that order on annexure 13 and 15, I filed a read appeal.
By that time, there was only 7 days delay. And in subsequent period, office pointed out that writ of appeal cannot be filed against 2 orders. You file against 1 order. Therefore, I prayed for withdrawal of the case with liberty to file a better one. And against the first order, now the writ of appeal is filed. In fact, there is no intentional delay. These are the facts which have happened. And this person, who is a poor person, against the order of a liquidator, the writ was filed, and after 7 years, the order is passed directing the petitioner to raise his grievance before the very liquidator. When this is sought to be modified, under annexure 5, the honorable court said that you raise the matter before the appropriate forum. And a poor person, this relating to some benefits, is now aged about 65 years. The amount relates to 1 lakh or something more.
Who's for the
State.
no notice is gone, is it?
No, this is state of opposite party.
No, this no state.
Notice was issued in 2020.
Opposite party appeal କରୁଛନ୍ତି 4 appeal କରୁଛନ୍ତି
3, 4, and 5. They will serve.
No, state.
Mr. Siddheshwar Malik appears for respondent.
I'm for the appeal for 5, my lord.
Ah.
I pray next week I file the counter, my lord.
All right. Counsel appearing for respondent 4. 5, 4 or 5?
Liquidator, my lord. Liquidator. Appeal 5, my lord.
Counsel appearing for respondent 5 states that he'll file an application, a reply both to the main writ appeal as well as to the application for continuation of delay. The reply we filed within 4 weeks, rejoinder for the next date. Second March.
Item 20.
I may plead your lordship. I seek 2 weeks time, my lord. I have, because I have not, because today morning matter was entrusted to me. Therefore, I'm not able to go
So
through the
Mr.
file.
seeks some time saying that he's in some difficulty today, 2nd March.
Interim to continue, ma'am.
Interim order.
Item number 23. For a shorter period, but I am for the respondent. I am for the respondent in that matter, my lord. Because my retirement benefits have been withdrawn.
All right.
That's the only thing I'm praying for a shorter date, my lord.
All right.
Item 23.
On behalf of Mr. Kekajana, let it come next week, my lord. He's not well today.
Counsel, the appellant is not well. List on 9th March.
Item number 24.
My lord, state is the appellant. Notice has been issued, but respondent has not appeared.
Because AD is not back.
Yes, ma'am.
What's the delay? All right. Fresh notice returnable 9th March.
Item number 25. Item 25.
None appears dismissed.
Item number 26.
May I please, your lordships? Here, my lord, the appellant challenges the impugned order on annexure 8, my lord, passed by the honorable single judge, my lord, disallowing the writ petition. Your lordships may kindly turn to page, running page 9, my lord. Running page 9, annexure 2, my lord. The appellant passed the +2 examination in the year 1996, my lord. Page 9, my lord. May I place, my lord? The 3rd, 4th line, my lord. This is to certify that Litu Manjari Pradhan of PS Junior College, Jharban has passed the 2nd exam 1996. She passed and she was issued with this certificate, my lord, for which she prosecuted her higher studies. I have filed the annexure 3, my lord. Next page, page number 10, annexure 3, my lord. She prosecuted her higher studies in Sambalpur University, and she has passed the Bachelor of Arts, my lord. Thereafter, the original certificate was not issued to the appellant, my lord, for which she applied before the respondent number 1 and 2 under Annexure 5 series, my lord. Under Annexure 5 series, she applied for her original certificate, but they did not produce the original certificate, did not submit her the original certificate, which, my lord, she submitted a representation to the respondent number 1, my lord, under Annexure 6.
See, you did not pass the education paper, sir. You passed the English in compartment, but not education.
Yes, my lord.
So how can the issue?
That was not within the knowledge of the applicant, my lord.
Still, the fact remains that you have not passed, sir. The fact remains you have not passed.
She has secured for 80 marks out of 200
It's not the
marks.
pass marks, sir. That's the unfortunate part.
This honorable court has also passed, if it was not within the knowledge of the applicant. my lord.
No, whether it's not within your knowledge or not, if you have not passed, you have not passed, sir. The fail can't be converted into pass because merely you were not aware of it.
Not only me, my lord. It was also the principal.
Whatever, sir. Whatever.
And the
somebody has evaluated your answer sheet. Somebody has given you a mark. Correct?
My lord.
That mark cannot be changed.
That mark cannot be changed. my lord.
Whether you are aware of what that mark is or not aware, that can't be helped.
I have got 2 judgments, my lord.
All right.
Of this honorable court.
All right.
Your lordship may kindly peruse the judgment. First one was 74, 1992 CLT 350 mile. Petitioner's no knowledge of his failure in annual high school certificate examination in 1982. Further prosecution of studies and joining government service. Came to know his failure in matriculation examination after lapse of 6 years. Estoppel applies, my lord. Here, my lord, after 10 years, my lord, the applicant knows, my lord.
A judgment reported in Nrsimha Charan Panda versus Secretary Board of Secondary Education 74 1992 CLT 350, which holds that if a petitioner had no knowledge of his failure in the annual high school certificate examination and subsequently joined government service, and came to know of his failure after lapse of 6 years, the couple would apply. And the opposite party, number 1, would be stopped to take the plea that the petitioner has in fact failed. Correct. In the considered view of this court, if it is an undeniable fact, as in the present case, the petitioner has failed in one of the subjects, single quotes education, in the annual CHSE examination of 1996. The fact that she may not have been aware that she had failed would not change the fact that she has in fact failed. So stop with the candidate having failed in one of the papers. It is not possible to direct a mandamus, issue a mandamus that the authorities should issue her an annual CHSE examination 1996 passing certificate. Stop. In that view of the matter, with this court being unable to agree with the above conclusion of a coordinate bench of this court, the matter is referred to a larger bench of this court for considering the question whether the aforementioned decision has been correctly decided.
All right. Item number 27.
May I please, madam? Disciplinary proceeding was initiated during the personal service. I given a date chart.
Who's appearing for the respondent, sir?
Respondent.
Kaushik Nanda, Ananda. None appears for the respondent. The matter is called out. In the interest of justice, let's stop. 16th March.
Item number 28.
Please, your lords. Thus, pursuant to a disciplinary proceeding, my lords, the so-called was issued, my lords, and the inquiry officer proposed for compulsory retirement. And thereafter, so-called was issued to the respondent number 1. And after receiving on the same day, your lordship may come to straight away. Page 16, para 12, my lords. Delay of 11 days, my lords. The third question in what case, my lords, after 42nd amendment of the Constitution, so far as Article 311 is concerned, whether before imposing punishment, my lords, a second show cause is to be issued or not. And that is a decision of the Honorable Apex Court. I'm extremely sorry, my lords, I'm having one copy of the judgment, my lords. Well, also, para 12 at page.
We are used to it, sir.
Fund?
In the Orissa High Court, at least in the last 2 years, I have been used to it. 2 judges are entitled only to one copy.
Sorry, my lords, I'm
that's the rule. I'm seriously thinking of amending the rules to say a division bench is entitled to only one copy of a judgment.
That's now.
And judges should only share a copy.
Sorry, my lords.
We'll amend the rules, sir. Very soon we'll amend it. Yes.
Para 9, your lords, mercy. Para 9, my place, lords. The civil appeal arising out of special petition civil so-and-so is directed against an order passed by the High Court in latest patent appeal.
No, I thought the proposition you're advancing
yes,
is that a second show cause notice is not necessary.
Not necessary. After 42nd amendment, lords.
Where do you have that? Counsel for the appellant relies on the judgment in State Bank of India versus Mohammed Badruddin. AR Online 2019 SC 507. And submits that after the 42nd Amendment to the Constitution, the necessity of a second show cause notice at the stage of penalty has been dispensed with. See, notice returnable.
What is the limitation as well as 11 days delay, my lords?
Both on delay and 16th March.
Item 29.
May I please, Your Honor, my lord? I'm sorry, my lord, I've come to the beach, my lord. My lord, this is a case, sir, the appellant is the Union of India and file the appeal against the order of announced single judge, my lord.
127 days delay.
Yes, 127 days delay. My lord was issued notice and in the meanwhile they have filed the content, my lord. This is a very peculiarity case. It's a very small point, my lord.
1 minute. Have the other side been served? You are appearing for the other side. Who's appearing for the other side? One Mr. Manti. Yes, Manti. None appears for the respondent when the matter is called out. in the interest of justice list of 16th March.
Item number 30.
Interim order to continue. All right.
Item number 30.
Babita Sahu appearing with the Lordship may reflect his name.
All right.
May I please, Lordship? 15 days delay for filing the writ appeal. My lord.
Notice is not gone.
My lord.
We say notice both on the appeal as well as delay. Returnable 23rd March.
Weekly list item 31.
Lordship, item 31 not pressed.
Not pressed, dismissed.
Item number 32. Item 32.
None appears dismissed.
Item number 33.
Writ appeal was filed, the writ appeal was, the defect was pointed out that 6 rupees court fee was sought for. On the very first day of listing, that was dismissed. And though I have asked for a 1 hour time so that I can file the deficit court fee of 6 rupees, which might have been slipped away while I was filing the writ appeal. But that has been dismissed. I have already filed that 6 rupees court fee. This may be restored so that writ appeal can be disposed upon its own merit, my lord.
What is the issue on merits?
On merits. On merit, my lord, the writ appeal is filed against, writ application was filed against the order of the execution.
How is a writ appeal maintainable? How is the writ appeal maintainable?
Only because it's filing out of 47 petition, my lord.
How is a writ appeal maintainable, sir?
The writ application was
the writ
filed.
petition itself assailed an order passed by its civil judge junior division in a CMA arising out of an execution case, rejecting a petition under section 47 CPC.
Yes, ma'am.
In the circumstances, the present writ appeal is not maintainable and is dismissed as such. First, you say CMA appeal is allowed, and then writ appeal is restored, and then writ appeal is dismissed on ground of maintainability. All right.
Item 34.
Lord, in item number 34, I'm appearing through VC.
Yes.
Lord, this is a writ petition challenging the order of the Industrial Tribunal rejecting the application of the petitioner to mark 795 notarized affidavits of different workmen as exhibits.
All right. Notice returnable. 23rd.
Lord, the Industrial Tribunal is proceeding with the matter. Your Lordship may have filed an application IA for stay. That's IA number 14704.
What is the stage of the matter there?
Lord, the evidence of the management is to be taken.
So why did you wait till the stage for filing that application?
After we filed the written statement at different stages, the workmen came up with 795 affidavits stating that these 5 workmen do not represent them. And there are 2,900 employees throughout the state, and we offer only ambulance service to the government hospitals.
When you make it a shorter date, you say notice returnable 2nd January. We won't stay it, sir. Let notice return 2nd January.
The matter is coming up in
Notice on the stay as well. Yeah.
Very well. Very great.
Item 35.
May it please your lordships. Here, my lords, a warrant of search was issued against the assessees. The lordship will find page 26 of the Panchnama.
Anyway, this is an appeal, statutory appeal.
Statutory appeal.
Notice. Can admit it and frame the questions? Or?
Lordship issue notice because the Lordship see the order, you will issue notice.
I have not completed. You are standing. I have not yet completed.
No, I asked him. I asked him whether we can frame questions.
My lords, I have understood. Thank you very much. My lords, here what has happened. I'll only take your lordships 2 minutes. I'll take, if your lordships kindly permit me, I'll take only 2 to 3 minutes, my lords.
All right.
My lord says such a seizure operation was carried on
in the business premises of Yazdin International Private Limited. And the stock and inventory was made in the case of Yazdani International Private Limited. Lordship will see the Panchanama which I have attached.
No, do you want us to allow the appeal today itself?
No. My lords, what I mean to say that, with your lordship's kind permission, this is a case of 150C.
Right.
This is not a case under section 153A.
Yeah.
So as to clothe the assessing officer the jurisdiction to proceed again under section 153A. This
is that PepsiCo, that Delhi High Court.
PepsiCo case and your lordship's own judgment. In my case, my lords, I have given, last year lordship rendered this high cashew case, that the assessing officer has to record the satisfaction that these documents belong to a third person.
Correct.
And here, the assessing officer has relied on the document. My lords will be pleased to see that the assessing officer has only relied on.
No, but all this argument is for stay.
For stay.
Yes.
Lordship will see.
What is the stay for? What is happening?
Stay of realization of the demand, my lords. They clear.
So was there a stay during the ITAT's appeal?
My lords, ITAT, lordship will see that page 124, CIT appeal. This ground was raised at para 6.
No. What was the stay in your favor during that period?
ITAT, my lords. ITAT simply my lords, oblivious of the grounds.
No.
At that stage, what was interim protection?
Interim protection, my lords.
During that period.
During that period, yes, my lords. He not unable to answer the, but your lordship will see.
So there's no imminent threat. That's what we mean.
My lords.
There is no imminent threat. No.
Imminent threat, my lords. They will immediately cross hold of my neck.
Will they?
Yes.
No.
I'm 100% sure.
They even lift their hands out of their pockets for doing that, you will immediately come to the court.
My lords, at least, lordship will. I have got such a very prima facie case.
You're very intimidating, sir. So they will not.
Lordship will not grant me stay, my lords.
Will issue notice on stay. That itself, when they know Mr. Siddharth Rai has got notice on stay, they will.
Yes. That will do, my lords. Notice on stay. Yes. In both the appeals. Notice and all.
Or appeals, you say notice both on application for delays condoned, notice on the appeal as well as application for stay. Mr. Satpathy accepts notice and states that he'll file a reply to the application for stay.
Yes, ma'am.
All right. List on 9th January, sir.
9th January. Obliged, ma'am.
Right, sir.
Item 36.
Same.
Item number 37.
Obliged,
ma'am. Item number 37.
May I please your lordship. Last occasion, my lord has directed to take instructions with the Lord and Government Advocate, my lord.
Right.
On dated 15 September 2022, my lord.
Right.
Well, as I have received instruction, there were two FIRs, my lords. One pertained to my lords assault between the two parties, and the second was pursuant to the junior engineer's report. So, with regard to the assault case, my lords,
file an affidavit.
Please, my lords.
Mr. Mohanty states that he has received instructions and he'll file an affidavit within 2 weeks with an advance copy to consult the petitioner, who's permitted to file a rejoinder thereto for the next date. 9 January.
Item 38.
38 may I please. This is a case of my lordship with the direction for two opposite parties regarding establishment of new LI point in different villages of Balrampur Panchayat.
All right.
I have approached all the opposite parties.
Where's the proof of that representation?
All the page number annexure 1 series to page number 10 onwards.
No. Where's the proof? Proof of
dispatch.
Delivery.
Dispatch and delivery. Dispatch is there.
The last one. Okay, the petitioner's representation dated 17th August 2022, bracket Annexure 2 series, shall be examined by the. You addressed it to the executive engineer irrigation.
I only prefer the notice will be issued to the opposite parties, then he will appear, then he will. There is no leave.
No, there is no necessary either collector or executive engineer, your lordship.
Executive engineer irrigation department, Baleshwar, and after hearing the petitioner, a reasoned order shall be passed there or not later than 9 January 2023 and be communicated to the petitioner within a week thereafter. The court clarifies it does not explain the matter. What about the next one? Same thing.
Same. 39. Next one is a application for examination of drain discharge of flood water.
All right, same thing. Representation. Same thing.
Item 40.
Obliged.
So, item 40, my lords may kindly look at prayer bills at page 17. In this case, I have made 2 prayers bills.
No, you are appearing in all matters.
Sorry, my lords.
You are appearing in both the matters.
Item 40 bills.
There are 2 items, sir.
Item 40, I am on 546. Second matter.
All right.
I am on second bills. 546 bills.
548. Who's appearing 548?
Graphite India versus State bills.
Right. Who's appearing 548? Okay. None appears in 548. In 546.
546 bills.
Same
17.
order. Yes. Sand City. Same order.
No, 548, 546 I am appearing here. Graphite India.
That's right, sir. So 548, nobody's appearing. You've disposed of.
My lords.
I know, but the long day.
546, I have made 2 prayers bills. One is bills, so far as bills challenging the. Constitution is concerned, covered by judgment of Honorable Apex Court dated 28 March 2017. Bills.
So the same order, sir.
Same order. But I have also challenged by order of reassessment by Annexure 2. Your lordship can relegate me to approach the appellate authority, like the one your lordship have allowed in earlier other matters also. Because apart from challenging enactment bills, validity of the act bills, I have also challenged order of reassessment by Annexure 2 at page 25. So I pray your lordship to relegate my approach to appellate authority.
All right. As regards the prayer B, it stands covered by the judgment of the Supreme Court in Jindal Stainless versus State of Haryana 2016-11 scale 1. So as regards the challenge to the order dated 13 June 2013 in the reassessment proceedings, counsel to the petitioner seeks leave, senior counsel to the petitioner seeks leave to withdraw the presented petition with liberty to approach the appellate authority in accordance with law. If such appeal is filed not later than 2nd January 2023, accompanied by an application for continuation of delay, explaining the delay on account of pendency of the present petition, it will be considered on its merits by the appellate authority. The court clarifies it is not expressed any view in the matter. This return, you need return of annexure.
Annexure 2 original may be returned.
Annexure to be returned, subject to be substituted by an attested photocopy thereof.
I have given a copy of Honorable Apex Court decision dated 28 March.
Not necessary, sir. Right. Yeah.
Item 41.
I am on receipt.
Yes.
Lordship will see that there was an interim direction on 22/4/2014 by the then Chief Justice Goel that 1/3 payment. So till date, but we have made the payment. But one aspect with regard to is that Jindal Stainless Steel case has been discussed and it has taken care of the proposition. But again, then one doubt that some civil appeals were preferred before the Honorable Apex Court in Bharti Airtel. In the Bharti Airtel case, my lords, which was directed to be disposed of by this Honorable Court, therein, my lords, again this point came up with regard to the virus, which was open. I am not aware of whether that decision has been taken place or not.
We'll go by the Jindal Stainless, sir. As far as we are concerned, we are bound with Jindal Stainless.
No, your lordship may kindly see this.
And Reliance also has gone against you. It's covered by both the judgments, sir.
No, this judgment of Bharti Airtel, your lordship has come across that judgment, which is before this Honorable Court for further application.
Where is Bharti Airtel
Limited? Bharti Airtel Limited case.
Where is that, sir?
wherein the interim order was modified. There it is, your lordship.
Where is that Bharti Airtel decision, sir?
My lord, the government has issued a letter. The commissioner, I have not submitted it before.
Mr. Ratha, I think I asked you a question.
My lord.
Where is the Bharti Airtel judgment?
My lord, I will submit it on records here, but I have not provided it to your lordships. Bharti Airtel judgment, where there is a Justice Sikri has clear-cut taken note of the general.
So you have a photographic memory, sir. My memory is very bad. I'm unable to recall the Bharti Airtel, much less Justice Sikri's observations. Unless I see the judgment. You'll have to excuse me, sir.
I'll provide it to your lordship. We keep it next week.
All right. Mr. Ratha states that he needs time to produce a judgment he's relying on in support of his submission. Let's list on 23rd March.
Item 42.
The lordship's kind permission, I got the instruction that they have paid 20% of the demanded tax amount and were enjoying the stay.
Let's file, my lord. Let us file my objections.
All right.
Very good.
That's fine.
You also verify.
Yes. Yes.
Item 42.
Wait, pleasure, lordship. Direction was given to approach the tribunal. Accordingly, I had approached the tribunal regarding the order passed, ex parte order passed by the Lorraine Principal CIT. But the relevant portions that
But you withdrawn, sir. The impugned order says you withdrawn.
It's not withdrawn, but it kindly have a glance to page 22 and page 23, which the Lorraine Tribunal said that the direction of this Honorable High Court is not carried out because that they said that it is not applicable.
No, but how is this writ petition again maintainable?
No, because when they have refused to entertain certain paras they have made, that which their rectification petition are there, when they have dismissed the appeal without dismissed the petition without giving the opportunity of hearing.
No, how is a writ petition maintainable? I don't understand. Once an ITAT has dismissed an appeal, how is a writ petition maintainable, sir?
Dismissed the appeal that they have only said here in this case that your lordship direction approached the Honorable Tribunal that they have refused to entertain.
Whatever it is, sir. Against ITAT dismissing your appeal or disposing it off, only a further appeal is maintainable here, not a writ petition.
Your lordship, I may be permitted. Lordship, permission I can say. Here is a lordship directed.
Okay. Go to the
In this case, your lordship directed to file appeal against the order of the 191B.
Correct.
Before tribunal. Tribunals that not maintainable because it's not before the tribunal cannot adjudicate the matter. Thereafter, your lordship is tribunal is kind enough to pass the order and directed the principal commissioner to review that order. Kindly similar running page 42.
No.
Yes, directed to review the order. Your lordship page 42. After taking all these issues, we direct the assessees at liberty to file review petition and representation before the PCI is same should be adjudicated by the PCI to the view of judgment on Supreme Court in case of Radhaswamy Satsang and honorable order of this High Court, and the tribunal dated all related provision act and rule made thereunder by passing a well-reasoned corrigendum order.
And they have not done that.
No, they have not. They have not preferred. They have filed, and again, another petition be annexed. Next page 44. They file a miscellaneous application before this tribunal. Tribunal has rejected the same. He said that once the High Court has directed to entertain the appeal, so the tribunal is error in law for not passing the appeal.
Anyway, this order of the ITAT can't be challenged in a writ petition.
Yes,
sir.
that is second issue.
So, my lord, have directed me to approach the authority based on presidency Radhasan subsection. But at this, in the said order, I'll have a glance to page 40. At para 17, they say that 1192B, when the order was passed, the rejection order was passed by the commissioner, he said that without granting the opportunity, rejected the order ex parte. Then I approached your lordship. Your lordship said that you again go to the tribunal, and they accordingly passed an order. That order is to approach at para. That is 23.
You got the relief that you wanted. They've given you one more round before the principal CID. I don't know why it should be bothered.
If this is not, if that is 17, that para they have said is not success, they have not considered. Then I have no case there. I will withdraw mine. Which one
Sorry?
again after them.
No, you have to go before the principal CIT. They've given you one more round before the principal CIT. They've said you can file
only a para 17, they said that since matter was disposed of by expert 1192B, it is not appellable. Yes. Then I approached your lordship, kindly have a glass to page 23, that this application filed by the petitioner, it is clarified petitioner permitted to file appeal before the income tax appellate tribunal, ITAT, the explanation offered by them for delay in filing, all these things should have. When application was filed, they said 1192B is not applicable.
So anyway, no prejudice has been caused. You've got another round before the principal CIT.
Principal CIT has, then your lordship may pass an order, then we'll approach again to the CIT.
That's already there. Why should we pass an order? Even if you dismiss this writ petition, the same thing will happen. Even if you dismiss the writ petition, the effect is the same. The ITAT is already permitted you to go to the principal CIT.
But only para 17 said that 119 is not available before us.
Why should we go into that question at all? After all, you've got a relief.
Then I will approach them again.
Under the order dated 23rd December 2021, the ITAT is already permitted the petitioner to again approach the principal CIT.
A time limit may please
by a review petition / representation. That view of the matter, with the petitioner having been granted the above relief, the court sees no reason why it should interfere with the impugned orders of the ITAT. The writ petition is dismissed.
No, my lord, time may be given so that I can approach them. So within that
period, if you want to withdraw this writ petition, then we can do all that.
Yes, I will withdraw.
Counsel to the petitioner seeks leave to withdraw this writ petition with liberty to approach the principal CIT with the review petition / representation, which liberty has already been granted to the petitioner by the impugned order of the ITAT. Disposed of is withdrawn with the liberty is freed for. All right.
A time limit may be.
No, but there's no time limit fixed.
2 months after we dispose of the matter because pending since last so many.
If the review petition / representation not later than 2nd January 2023, it shall be disposed of by the principal CIT within a period of 2 months thereafter. All right. Continue.
Item number 43.
Item 43, my lords, may I just humbly pray, my lords. This order, my lord, is in complete violation of your lordship's order in Keshav Auto Mills. May I just pass on the orders of Keshav Auto Mills before I take your lordships to the relevant portions?
You will issue notices coming up for the first time.
It's coming up for the first time, my lords.
Notice, all right.
And
who accepts notice?
There are 2 miscases. The first one is for stay. So may I humbly pray, my lord, no coercive action till the next statements.
The assessment for both the periods, pre-amendment and post-amendment.
So one has to
That
go.
Application for dispensing with that is allowed.
No, that's
application for stay till the next date, no coercive action be taken. In the main writ petition, say reply within 8 weeks, rejoinder from the next date. List on 23rd March.
Item 44.
44, my lord, is a case where, in spite of the fact that this provision of provisional assessment, my lords, in the CST Act has been done away with effect from 1/10/2015, an order, my lord, a notice is issued, my lord, for in 2017. If your lordship would see the notice annexure 2 at page 45, my lords. Lordship got it?
Here again, it's coming up for the first time.
It's coming up for the first time, and similar matters, my lord, your lordship have been kind enough to direct that there should be no coercive steps pursuant to the assessment order, my lords. And these 4 matters are coming up on 29th. It was listed. It was directed to be listed on 29th of November. But
we'll simply list it on 29th November with that.
In the meantime, let there be no coercive action pursuant to the.
All right. Notice, he accepts notice, list on 29th along with writ petition civil 19774 of 2021. No coercive action to the next day. Right.
Oblations.
Item 45.
May I please your lordship? In this case, appellate order under GST Act has been challenged. I have paid 10% tax.
You say since no second appellate tribunal has been constituted, this petition is being entertained. Notice, he accepts notice. Reply within 8 weeks, rejoined for the next date. You say in view of the fact that the petitioner has paid 10% of the tax at the first appellate stage, subject to the petitioner paying 20% of the remaining tax within 4 weeks, no coercive steps shall be taken against the petitioner. List on 22nd March.
Item 46.
May I please, Lordship? Lordship, this matter relating to GST cancellation registration matter, Lordship. Lordship, usual order may be passed. Lordship, subject condition to deposit.
Same order, sir.
Lordship. 47 and 48 is same, Lordship.
46, 47, and 48.
Lordship, I am appearing for opposite party number 3 for 46, 47, 48.
All right.
Item 49.
Item 49 and 50 on behalf of Mr. Das stands covered by a lordship judgment in Harish Chandra Machi, my lords. So the lordship may dispose of these 2 matters in light of that.
All right.
This SOR was challenged and the lordships have declined to few minutes.
All right. So both petitions are disposed of in terms of the judgment dated 7th June 2021 of this court. In writ petition civil 14924 of 2020 bracket Messrs. Harish Chandra Maji versus State of Orissa.
50 is also the same.
Same, right.
Item 51.
May please, Lordship. Now, here the petitioner challenges the decision of the Excise Commission under Annexure 4 as at page 13, wherein he has been directed to imposing fine on some irregularities. Not so cause notice under Annexure 2 by the Inspector Excise saying that you file your reply before the Deputy Commissioner, Central Division, but I filed the explanation before him, but Commissioner has passed the order. And also he has passed an order applying Lord Section 64. Section 64 Lord fine says if there is a willful, then the 50,000 fine will be imposed. Lordship kind of glance Section 64. I am coming under 64A, but he has applied Lord 64B and C, where it says willful Lord irregularities. There is no finding to the effect that there is willful irregularities. Some irregularities are there. I have stated my explanation and I have cured also that defects also. Here is no penalty has been imposed, Lord.
Anyway, no stays.
50,000 penalty.
No offense. No offense has been made.
And revision is maintainable against that commissioner's order.
It is not reviewed. It is not revisable. Excise Commission has passed order.
It is the commissioner's order under Section 6. It is revisable before the secretary, the excise and.
Lordship can decide it. Short point.
In all the cases, your lordship is.
All short points we need not decide.
64 he has applied, and also he is not
also
the authority to decide.
Withdraw this petition, liberty to approach the Secretary Revenue by way of a revision petition
under Section 6.
Under Section 6 of the Orissa Excise Act. Disposed of is withdrawn with liberty is paid for.
Item 52.
None appears dismissed.
Item number 53.
53. No instruction.
No instructions dismissed.
Item 54.
None appears dismissed.
Item number 55.
My lord, 55. State is the review petitioner.
Only 1453 days, sir. There's a delay of 1453 days in filing this review petition in view of the explained extraordinary delay. The application is dismissed, consequently the review petition is dismissed.
Item 56.
340 days.
Here
Delay
also.
dismissed.
Item 57.
None appears dismissed.
Item number 58.
None appears dismissed.
Item number 59.
15 lawsuits was admitted on 17/8/2022. Only notice was issued in this case.
Yeah, so notice is valid notice.
And as already, sir.
I beg to appear for the respondents.
Yes, yes. We'll have it on some other day, sir.
Well, there is a short point covered by the Supreme Court.
I see.
Yes, Manoj. May I just point out the controversy in a minute, Manoj?
Yes.
I made certain remittances to non-resident parties for import of material and services. The tax office, the assessing officer initiated reassessment proceedings, the original assessment having been completed under 143(3), on the ground that the entire payment needs to be disallowed under 195, since I did not deduct tax at source. Because the reasons are based on the then Karnataka High Court view, which was that each time you make a remittance, withholding tax must be effected. Because that came to be reversed by the Honorable Supreme Court in G India Technology Center. 210, 10 SCC 29. My learned friend Mr. Jena is carrying the copies. Because this decision clarified that unless the payment is chargeable to tax in India, mere remittance to a non-resident will not attract withholding tax at all. And if Maloj will just see the reasons recorded.
But why was this not cited before the ITAT?
Well, the ITAT is held in my favor.
It's not a revenue appeal.
No, but was this decision cited?
Yes, in fact, Maloj, the ITAT has quashed the reassessment in itself. The ITAT has said there is no new material, there's no eligible material. That's what I was shaking my. If Maloj will see the assessment order, the first page. Well, the assessment order starts at page 17 in the appeal.
Yes.
Maloj will see the first para, the fourth line. It says, the original assessment was completed under 143(3) on 31st December 2011. Thereafter, Maloj, the next para, thereafter reassessment was initiated, and Maloj will see the reasons which are quoted. Further verification of the assessment records, it is revealed that as per information available in the record, assessee company has incurred debited an expenditure of so and so lakhs towards import expenditure, 93 towards legal consultancy and commission on which no tax has been deducted, not eligible for deduction under section 40AI. Then Maloj will turn the next page. Besides the above verification of assessment record, it has been revealed there was a closing stock of so and so to the query raised by the assessee. The assessee has submitted in which the closing stock was at so and so. Apparently, there is a suppression of stock. Because this issue was dropped by the AO himself, no addition made in the assessment order. So the only issue which remains is 40AI disallowance. This Maloj will now kindly see the decision of the Honorable Supreme Court.
Anyway, let's ask. What do you say?
Lord, here the only issues, Lord, tribunal has passed the order that only ground of change of opinion, Lord. Only ground. So far as the other fact, tribunal has not dealt with. So your Lordship, see what my friend is placing, Lord. These issues have never been considered while passing the order of regular assessment. The issue which has been raised in the reassessment proceeding has never the issue before in the original
material. There's no material, sir.
No, these
no additional material.
No, this is.
But anyway, even if assuming it was not considered, this judgment covers it completely.
On facts, Your Lordship,
there's no liability under 195.
No, the 195.
In fact, Maloj will, even on that, the first part, my learned friend may not be correct. Just see Maloj page 20 of the appeal, the assessment order. Maloj, the specific query was raised in the original assessment. Kindly see, Maloj. If Maloj will see, is this import of material, my explanation, Maloj will see the fourth para. we have enclosed statement showing vendor-wise details of import, raw material, etc. made
Your
by the
Lordship,
assessor.
may I, Lordship, kindly keep it tomorrow. I'll file one judgment. Lordship may pass the order based on the judgment of the J. Lord. One judgment I have to cite, Lord. So far as this issue is concerned, Lord, I am not having today.
What judgment?
Lord, I'll just, Lord, so far as the issue which has been later on pointed out by
Mr. Jolly, learned counsel for the respondent, states the issue stands completely covered in favor of the SSC by the judgment of the Supreme Court in GE India Technology Center Private Limited versus Commissioner of Income Tax 2010 10 SCC 29. Paragraph Mr. Satpathy, learned senior standing counsel for the department, states that he has to cite a certain judgment which he does not have with him today. List on 21st March 2023.
Milord, the IN number maybe considered, Milord, that has not been IN numbers 16 up to 19.
Yeah, that is allowed. Already.
That is allowed.
Item 60.
Delay.
Milord, as per the tribunal order, the matter is set aside, but I have to take instruction. The department will give instruction, Milord. The question of law is, I'll say.
No, I'm not able to follow. What are you saying, sir?
Current position or wants to
matter was set aside. Which matter?
No, tribunal.
The question I
remanded.
Remand.
Set aside, I'm not. Sorry, I'm a bit slow in these things. Huh?
Sorry, sir. I am also. I understood, but I couldn't.
Yeah. These mean specific things to me. There's only a remand order, sir.
Remanded. The New Noble Education Society letters judgment by the Honorable
In the remand, they will apply that, sir. You say these appeals by the delay is condoned. These appeals by the revenue are directed against corresponding orders of the. All these connected matters are disposed of or pending?
Yes. They take instruction because
they're all disposed of cases.
No, all cases are disposed of. On the monetary limit.
Okay, these appeals are directed against the common order dated 5 July 2018 of the IT, in which matters have been remanded to the assessing officer for making fresh assessment in light of the observations of the IT. But substance, it is only an order of remand. The court is not inclined to interfere or to frame the questions by the revenue. The appeals are accordingly dismissed.
Item 61.
'61 and '62, in order to free the government land, my lord, through registered post, my lord, the petitioners have submitted their application for the collector, page 16. So, my lord, alleging against the OP number 4, who is the encroacher. So, my lord, page 16, the registration slip 11/8/2022, the grazing field has been encroached by the OP number 4.
Anyway, representations.
Tahsildar.
Or the petitioner's representations, bracket, annexure 3 series, shall be examined by the collector. Balisha. And after notice.
Better, it should be examined by Tahsildar Bahanagar.
Okay.
Opposite
Tahsildar
partner.
Bahanagar. And after notice to the petitioner as well as opposite party. 4. A reasoned order should be passed thereon not later than 9th January and communicate to the parties within a week thereafter. The court clarifies it has not expressed any matter.
62 also.
My lord, 62 also same, my lord. OP same, but
or same order.
My lord.
Item 63.
May I please, your lordship? My lord, this matter relates to Sri Jagannath Temple. PIL. The allegations are almost same.
This matter has already been dealt with by the Honorable Apex Court.
They are coming with a wall. My lord, that particular wall is not in the project. So it is a non-approved thing. So they are violating the Supreme Court guidelines, which says that they will work with the coordination with the ASI.
You first take instructions. What is only on a news item?
It is only based on news item.
That's what you take instructions.
No, I have personally inquired, my lord, and I have also sought on document. I will show but because of some difficulty, I am not able to physically appear.
So whenever you overcome the difficulty, we'll take up the case, sir.
My lord, maybe
All right.
tomorrow.
Yeah. No, you have so many difficulties. So
No,
we
my-
don't want to come in the way of those difficulties.
My lord, I'm sorry for
Not
that.
tomorrow.
There is a
It's all
genuine
right.
problem. Because of that, I could not.
All
able
right,
to-
all right, all right. The counsel for the petitioner has some genuine difficulties today. List on. February 7th. Yes.
Item 64.
Representation pending for OP to collector, my lord. Gochar land is capturing by the.
Made a representation.
Annexure 2. At page 10, my lord. Representation is pending before OP2 collector.
Where's the proof of this representation been sent, sir? Some email you've just. Where's the proof of submission of this representation?
Highly fresh representation, otherwise highly or
fresh representation. Counsel the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation. And after following up with such a representation, to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty is prayed for.
Item number 65.
May I please, my lord? My lord, I pray this matter maybe tomorrow. I have to submit some documents.
All right. Mr. Mishra, who appears in person, wants to submit some documents. List on
tomorrow.
11 January.
Item 66.
It will be too late, my lord.
That can't be helped, sir. That can't be helped. Yes.
Item number 66.
Item number 66 pass over for tomorrow, sir.
Counsel for the petitioner seeks a passover which is not convenient to this court today. Since there was a reference at 2 p.m., 27 January.
Item 67.
67, Lord, I'll remove the defects and thereafter it may be listed.
All right. Defects be removed within a week. List thereafter.
Item 68.
68, 69, and 70, my lords. These are GST appeals. In the absence of the tribunal, your lordship may pass.
All right.
Similar.
10% has been paid.
Lord, item 10% you have paid.
I have paid 10%.
So you say in all these matters, since the second appellate tribunal has not been constituted, these petitions are being entertained. Notice, reply within 8 weeks, rejoinder for the next date. In the IAs, you say since the petitioners paid 10% at the stage of first appellate, the subject to the petition paying 20% of the remaining tax within 4 weeks, there shall be no coercive steps against the petition.
My lord, I am appearing from opposite party number 1.
21st March.
69,
68,
All right, 21st March.
Item 68, 69, and 70.
68, 69, 70.
Item 71.
May it please, Milords. Milords, I beg to appear virtually, Milords. Milords, this matter, the assessee is a proprietorship concern. He has died. Despite that, notice has been issued to a dead person. Assessment completed. Demand raised and my bank account attached. I mean, the business's bank account attached. The proprietorship
notice. This he accepts notice. Reply within 4 weeks, rejoinder for the next date.
That's in my copy may be sir for opposite party number 3 and 4.
All right. 2nd January, sir.
That's some
Item 72.
Because, Milords, they have attached my bank account.
What's the amount there? What is the amount in the bank account?
Milords, the amount, Milords, is the demand. Milords, admittedly, Milords, once the person died, after that, your lordship can quash it and send it back to the assessing officer to do the assessment. Milords, that will suffice. I never got an opportunity to participate in the assessment. That's the difficulty, Milords. Here, Milords,
so what's the amount attached?
6.4 crores is the amount, Milords, the demand.
Please, sir, what is the amount in the account which has been attached? You file another IA for that, sir. Give us details. All right.
Milords, Milords, I'm sorry, Milords, I'm pressing lordships. Your lordship would
meanwhile defects we removed, huh? Yeah. Sorry, sir.
I'm sorry, my lords, I'm pressing your lordships for an interim protection. Your lordship may just indicate no course of action till the next day.
No, where's the question of no course of action when it's already attached? Where's the question of no course of action? The only interim order can be for lifting the attachment, for which we need details. See, normally in a bank attachment, and you're getting free legal advice now.
No.
You normally say, what is your need? How much you need for running your daily affairs? And I need to at least withdraw this much amount.
That's the
all right. File a separate IS.
Yes,
all right.
Item 72.
Gratefulness.
72. The next.
The same.
Item 73.
73, my lord. I challenge annexure 1.
Yes.
Which is an order rejecting the opening of my shop. Cryptically, your lordship may see annexure 1 without any reason. Lord, here what has happened, Lord, when I applied, they called for the objection, they followed the
some
rules.
appealable order, I'm sure.
Yes, I preferred appeal.
He's preferred appeal. And my lord, the collector has given, my lords, I filed my counter affidavit. There were objections, my lords. So therefore, my lords, under Rule 26, my lords, this.
So we'll hear it on some other days.
Please, my lords.
Today it's not possible. It's a list on. Since when has your shop been closed?
Pardon, Lord?
When has the shop been closed?
12th January. 12th January.
Item 74.
None appears to speak.
Item note 75.
75, I want to have Mr. B. Pujari. One week time may kindly wait. 74.
75.
74, my lord.
74 is a review petition of 2013, sir.
My lord.
It's a review petition of 2013. There's a question of entertaining it in 2022.
1 week time may kindly be given.
No, sir.
Mr. Pujari will argue the case.
No, sir. We're not inclined to do all that. You said there are no grounds made out for review petition. Right.
Item 75.
75, that amended cost title has been filed. This matter is looks at last date, directed the transport department to file the counter affidavit.
Have they done
that?
Have
not yet filed it.
All right. Last opportunity to the
item 75, my lord.
75.
75.
Central government is the main.
My lord,
central government or not
filed. Fix up time to because
last opportunity to file a reply within 8 weeks, rejoined for the next date.
Your lordship, 30th, my lord, similar matter is posting, my lord. Your lordship already posted 30th of this month.
That will adjourn to the same date, 21st March. All right.
Oblige, man.
Item note 76.
Let them serve the copy. There, one copy I've received, another copy we don't have.
Another copy today.
No, we have not received yet.
Yeah, meanwhile, defects be removed in all these petitions. Right.
Item 76.
76, I had taken time to file an additional affidavit, my lord, incorporating 2 orders, my lord. In the meantime, I have got the order and I will file within a week.
All right. Consider the petitioner states that he will file the additional affidavit within a week.
And the CMC be directed to file the counter in.
No, I have filed a counter copy is also served. I'll serve another copy.
21st March.
Item 77.
Hey, please, my lords. Lord, this matter relates to construction of bridges over River Potter in Malkangiri district, my lord. Lord, in 2 financial years, 2 bridges were sanctioned by the government of Orissa for under Biju Setu Yojana for construction of the bridge, my lord. In the financial year 2016 and 17 and 2018 and 19, Lord, 2 tender notices were issued.
So you filed the supplementary counter affidavit.
Ultimately, they filed the counter, my lord.
No, there was a supplementary counter affidavit.
Supplementary counter, my lord. They are also admitting my claim. Lord, your lordship may kindly see that supplementary counter. They don't say, my lord, that
para 5. Just see para 5.
Lord, para, your lordship may kindly see para 5, my lord. There is no necessity to construct a separate bridge at present connecting Sunali so and so. Then, my lord, last line. Although another bridge was proposed to be constructed at a distance of 2 kilometers from the bridge construction at present, now the same is found to be not commercially viable. My lord, executive engineer is not to decide, my lord, which is commercially viable, my lord. State government is not doing business here, my lord. They are giving connectivity to the poor rural in
next paragraph.
My lord.
Next paragraph.
My lord, and it will save state exchequer incurring additional financial burden.
Next paragraph.
Next
paragraph.
My lord, while preparing affidavit, the chief construction engineer, rural circle Sunabeda, Sridhar Naik was consulted, and with his instruction, this was taken into consideration while drafting the affidavit. My submission is, my lord, he is not the head. Head is the government, my lord. Let the secretary, my lord, let him decide, my lord. If second bridge is necessary or not, my lord, let the secretary, rural development department decide. My lord, it is the government who has consciously decided, my lord, to construct two bridges, my lord.
No, 1 minute. Mr. D.K. Manthi.
Yes, my lord.
So when the chief engineer, superintendent engineer and all tell us something, the government will tell us something else. That's what he's hoping.
That is not.
He says his secretary doesn't think the same way his
They
chief
are the
engineer.
nodal authorities. These executive engineers and superintendents, they are working on field. Whatever material they place before the government will accordingly file the affidavit. What he is saying that government cannot have a second say or different stand.
My lord, the government in its wisdom has consciously decided to construct two bridges. One in the year 2016 in which the construction is going on. And in 2018 and 19, another bridge was decided, my lord, for which I am claiming, my lord. My lord, had it been so, one bridge is enough, my lord, government would not have decided to construct another bridge in the year 2018 and 19, my lord. My lord, two tenders were also issued. Now they come before your lordship, now one will do, my lord. This is a rural, my lord, tribal inhabited, my lord, this Naxalite affected district, my lord. To give connectivity, my lord, the government has decided, my lord, they have given a map, my lord, your lordship may kindly say annexer F/4. Lord, how it will affect, my lord, the common people. Let secretary decide. If the secretary says, my lord, no second bridge is necessary, my lord, if matter ends there, my lord. My lord will not. Either let them file.
My learned friend thinks that the executive engineer is giving such an affidavit without the approval of the whatever affidavit we used to file, that is already vetted by the government. That government without the knowledge of the government. No activities.
Lord, your lordship, let the secretary file an affidavit before your lordship. Lord, let it be decided by the secretary.
Your lordship is that so and so officer will file the. Tomorrow you will say that let the minister file this affidavit. No, that is not.
What happens? One stand in one affidavit they have taken. At the time of argument, they take a different stand. Therefore, your lordship directed them to file second affidavit. In the second affidavit, they don't deny that there is no necessity for a second bridge. They, Lord. Although another bridge was proposed to be constructed at a distance of 2 kilometers from the bridge under construction at present, now the same is found to be not commercially viable. Lord, government is not doing business. Lord, it should be socially viable. Lord, giving connectivity to the rural people, Lord, tribal injured people, Lord, this Naxalite affected people.
What is anyway? What is commercial?
It is only, Lord, the expense is only 10 lakhs, Lord.
Collecting any toll or whatever.
No,
what is this?
My lords, may kindly see the map, my lords, which we have given.
No, but what is commercial viability? I have not understood.
No, my lords, we are saying that this one bridge.
Are you going to collect toll? No. Then what is commercial viability? Tell us.
My lords,
what is the meaning of the expression commercial viability?
That, my lords, has not been.
If you don't use the right phrase, you're inviting questions.
However,
for construction of bridge.
Our submission is that the connectivity that
you better explain.
10 lakhs only, my lord. 10 lakhs for a mighty government, my lord. Popular government is nothing, my lord.
10 lakhs for the bridge.
For the bridge, my lord. To give connectivity to rural people, Naxalite affected people, my lord. Tribal dominated people, my lord. This is the dream for last 40 years, my lord. Everybody has recommended your lordship will find from MP, MLA.
Say, permit us to dictate if you do not find, sir. In the supplementary affidavit, it is sought to be suggested that constructing another bridge is not, open quotation, is found to be not commercially viable. Unquote. Stop. When the court posed a specific query as to what the state means by single quotes commercially viable, counsel of the states volunteers to file yet another affidavit explaining why the earlier decision to have a second bridge has now been recalled. Full stop. The affidavit be filed under the instructions of Secretary, Water Resources Department. What will be Secretary? Rural Works.
Rural Development Department.
Rural development.
Rural Development Department. All right. Be filed within 4 weeks with an advance copy to consider the petition. List on 7th February.
Item 78.
So, Lord, it will come on 7th of
February. Sir. Item 78.
Copy not served. Water Resources Department has filed counter affidavit. Let the government serve copy.
Yes, copy not served. Copy already served.
Copy of the compliance affidavit of the Water Resources Department be served on.
My lord, let me tell one thing only. For this particular project, we have already floated the tender and the work will be commenced soon. So there is no necessity to continue with this little case.
No, my lord. Let them serve copy.
Serve a copy.
Okay.
List on 2nd January.
Item 79.
Item 79, we have received a affidavit today itself. We wish to file a short reply to that same affidavit.
Adjourned to be filed for the next date, 3rd January.
We have just, we have in that affidavit, we have just read that 2 weeks time may be granted for, because it is already advertisement for issuance of the advertisement, only 2 weeks time may be granted. So let this matter be posted 2 weeks after so that
all right. Just take off that order. At the request of Mr. Monty, learned AGA, list on 8th December.
8th December.
Item number 80.
Item 80, I'm appearing for the OP number 3. I received my letter, Parawai's comment. 2 days time be given to file counter affidavit so that your lordship can edit.
Mr. Zafrullah appearing for OP number 3 seeks and is granted 2 weeks time to file a reply. Rejoined if any before next date. 8th March.
Item number 81.
81, my lord. 81, my lord. With regard to opening of Anganwadi center, but we have challenged the order of the learned collector at Annexure 4, page 27, my lord, where our grievance has been negatived. Our prayer before this honorable court previous and now that there's the additional Anganwadi center should be opened in our village, which is 4 kilometers away from the original revenue village called Botolama. Well, in Botolam village, there are 2 hamlet villages, that is Makara Behra Sahi and Baha.
You filed a consolidated petition?
My lord, I have filed.
All right.
My lord,
Copy may be.
All right. Notice returnable
consolidated.
21st March. Reply we filed within 8 weeks. Rejoined for the next date. All right.
Item 82.
Please, your lordship. Your lordship's last order, the stalemate which is prevailing at Orera due to non-execution of orders and a wrong misconception that we don't have the powers of civil court. Your lordship had directed the Orera and the state to how this can be sorted out.
I have filed a counter. State has not yet filed.
I'll take a week's time.
The order was that they will come up with concrete solutions. But there is no solution.
We will, my lord, we will do that.
My lord, since 5 years, a complete stalemate is remaining there.
All right. Consider the state seeks one more opportunity to file a reply. We filed within 4 weeks. Rejoined if any for the next day. We'll have to the opening day, 2nd January.
Item 83.
83 mallards already launched time mallards. I am very much hungry mallards.
We have to go for a reference now. We are not allowed to have lunch. I'm depriving my colleague also of his lunch.
They have to file a counter mallards. Lordship may keep it to in the month of mallards. Interim order to continue.
Interim order to continue. Reply within 8 weeks. Rejoined for the next date, 21st March.
Another is there, 86. Against me is Mr. Chimanka is appearing. Same SSC for the period 18-19, Lordship have posted it to 25th of January.
Right.
Same SSC. It is only 19.
List on 25th January. Interim order is there.
Interim order is there.
All right. Interim order to continue. All right.
Much obliged.
Item 84.
84 was a similar matter is WPC 14069 of 2012. It's coming up on the 5th of December, my lords.
All right. List on 5th is along with writ petition civil
14069 of 2012.
14069 of 2012.
Item 85.
So item 85, Lords, it's a despite of the petitioners complying the proceeding before the Lords DGCI authorities, Lords. Because after 2 years, again by another set of proceeding, the proceeding revived, Lords.
So counter rejoinder all filed.
Lords, and here counter, rejoinder, additional affidavit, all are filed, Lords. And that
on some other days.
My Lords.
List for final hearing on 28th March.
Item number 87.
87, my lord. In the morning, we have made a mention before lordship. The petitioner's son's marriage is on 3rd of December, my lord. So any day after
Say the
that.
council, the petitioner is in some difficulty today. List on 28th March.
Grateful, my lord.
Item 88.
Item 88, my lord. Will be permitted to withdraw with liberty to file fresh application if cause of action arises.
All right. All right. Counsel for the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition if any cause of action survives. As most of us withdrawn with liberty is paid.
89.
My lords, be pleased. My lords, I seek permission to file a fresh wakalatnama in this case.
All right. What's your name, sir?
My lords,
petitioner.
From the side of petitioners. And my lord, one request. My lord, this case has been tangling since last 7 years. But one thing which is missing in this.
Just hand over to him, sir. What you're having in your hand, what you hand over to that.
My lords, this GA department is yet to file its reply. That is the only problem. They are initiating the proceedings, but reply has been filed.
My lord, my record shows that it is served on the counsel of the petitioner.
Sorry, sir, I have not yet received.
It's all there.
Today.
Then how can I serve it to you?
Client
You get the files from the lawyer who was appearing before you.
Yeah, it will be open.
This is what I'm informed.
Yes.
So we have an easier solution for you. You have a pen drive.
I do have, so I can arrange.
Just give it to him. He'll give you the entire paper book in a soft copy.
Obliged, my lord.
List on 21st March.
Item 90.
Well, please, Lordship, in this case, I required 1 week time to file rejoinder, Lordship.
All right, rejoinder will file for the next day.
My name is appearing.
28th March.
I was appearing with the petitioner, my lords.
All right.
Meanwhile, I have joined the GST department as senior standing counsel, my lords. My name may be deleted from the array of the advocates and the petitioners, my lords.
All right, his name be deleted from the array of advocates.
I am appearing with the.
All right. Thank you.